Ladies and gentlemen, Mr. Chairman, it's time to begin the Metropolitan Government's Board of Zoning Appeals meeting, the regularly scheduled meeting of August 3rd, 2017. My name is John Michael. I'll be making the presentation of the cases to the board today for their review and consideration. Respectfully, here at the outset of the meeting, we would ask all of you to please silence your cell phones, tablets, or any of the devices you have, out of respect both for your fellow members of the public and for the board as they deliberate over the cases. And we thank you for that accommodation. In each of today's public hearings, we'll make a presentation of the correspondence that's been submitted, whether in support of or opposition to a case, a presentation of photographs, maps, site plans, and other data that's been submitted with regard to the appeal. In today's hearing, staff will present those items and then also have the opportunity to hear from any elected officials who are in the audience to make any desired presentations with regard to the cases at hand. At the conclusion of the staff presentation, the appellant will have the opportunity to present his or her case to the board. After the appellant's presentation, the board would hear from any of those wishing to speak in support of the appeal that's being presented. After those folks have had an opportunity to speak, the board would then hear from opposition if there is any present. After the opposition presents its testimony, the appellant would have a period for rebuttal. Under BZA rules, the appellant has 10 minutes for a presentation if there's no opposition present. For contested cases, both sides have a cumulative 15 minutes to make their desired presentations. As a reminder, that's 15 total minutes, not 15 minutes for everybody that's got a beef today. So divvy up your time appropriately. Happy to have you, but you do need to share that time. At the conclusion of each hearing, the board would deliberate and vote on each individual case. The board is vested with the power to act on these cases under the provisions of the Metro Zoning Code, Section 17.40.180. All of the section numbers that we refer to today come from the Metro Zoning Code. That was put in place on January the 1st, 1998, and applies to the entire jurisdiction of the Metropolitan Government of Nashville and Davidson County. I'll introduce the entire zoning code and make it part of today's record. The Metropolitan Code of Laws required a record of these proceedings. So, for anyone who wishes to address the board, it is imperative that you come forward and use one of the microphones here at the front table. Please identify yourself by name and address and then make the desired presentation. We're happy to have you here. We encourage you to participate in the process, but we do have to have a proper record of that proceeding. The Metro Code requires 4 of our 7 board members to be present in order to establish quorum. The code also requires at least 4 affirmative votes in order to grant an appeal. In the event that only 4 members are present for any individual hearing and an appeal fails to receive 4 affirmative votes, that appeal will be re-advertised for the next available public hearing. In the event that 5 or more board members are present for a hearing and the appeal fails to receive 4 affirmative votes, the case will remain on the board's agenda for the next 30 days. Applications that fail to receive 4 affirmative votes within that 30-day window shall be deemed denied by operation of law. Pursuant to board rules, an aggrieved party may file an appeal of a board decision to the Chancery Court via writ of certiorari. Additionally, an aggrieved party may file a motion for rehearing within 60 days of the original hearing date before the BZA, pursuant to the terms of the BZA rules and regulations. After that 60-day time limit, the board's decision becomes final and no further action can be taken. For the appellants, if your appeal is granted, you're actually required to obtain the permit for which you applied. A permit must be obtained within 2 years for a board approval to remain valid. After that time, basically, you would have to start all over again. It should be noted that if any false or misleading testimony is presented to the board, then any board approval could be revoked at a later date by means of a show cause hearing before the BZA. Mr. Chairman, I submit that all the cases have been filed in the proper order. The appellants have been notified by certified mail, and all legal notice requirements have been fulfilled. We do have a couple of preliminary announcements before the board takes on its first cases.
Yeah, before we get started, John Michael, this has just been a devastating week for Nashvillians, and particularly our mayor and her husband, Bruce, the loss of their son, Max. I first met the mayor when I was at Vanderbilt Law School, and she was at the business school right next door to us. And, you know, she has always been the kind of leader that we know today, and just someone that has wanted to kind of make the city and now even larger footprint a better place. Max kind of was the best combination of his parents. She had his mother's kind of compassion of helping others, and Bruce's wry sense of humor. And it's just a devastating loss for the city. And so I know my colleagues here share in our deepest sympathies for Megan and Bruce. And the city has just really kind of come together during this very sad time. Does anyone have anything else that they'd like to add? I would like for us to have a moment of silence in honor of Max Berry. Thank you. John Michael.
Mr. Chairman, we have 5 cases that are deferred from today's agenda, the first of which is case number 2017-161 involving the property at 4710 Charlotte Avenue. The second is case 2017-163 involving the properties at 2021 and 2023 Beach Avenue. I know that was not in your original packet from our office, but that is a late deferral for today's docket. The next, case number 2017-170 for property located at 4708 Charlotte Avenue. The next, case number 2017-183 involving the property at 5229 Earhart Road. And the fifth and final case to be deferred off of today's docket is case 2017-188 involving property at 884 Elm Hill Pike. Those 5 cases will be set to later dates, still to be determined, but will not be heard on today's agenda.
John Michael, I have
if I may, Mr. Chairman, just for the benefit of the members of the public, if anyone is here on any of those 5 cases we just itemized, they will not be heard today, and although you're welcome to stay, your case will not be heard, and therefore you're welcome to leave. Mr.
John
Chairman.
Michael, I know a lot of people watch this at home and never come to these meetings, and they probably look at the top of the meeting and they wonder what happens to all these cases that get deferred. So can you generally talk about how cases get deferred and when they come back?
The when they come back is a flexible item. In many cases, they come back at the very next board meeting. For us, that will be, August 17th, 2017. Others, it's a matter of maybe appellants are reworking their site plans or having another community meeting or something along those lines.
Working with their council person.
Working with their council members, which, of course, this board and staff always encourage. But that's something that remains somewhat flexible and up to the appellant to a large extent.
Sure. Okay, thank you.
We use this opportunity to recognize the elected officials who've come to join us in today's audience. I know I've seen at least 2 or 3 today, and at the moment I would take the opportunity to give them a chance to speak at this point if they wish, or wait until their cases of interest are called. First, Councilman Brett Withers of District 6. Do not wish? Very well. And Councilman Colby Sledge, District 17. Very well.
Thank you, Board, and good afternoon. There are now 3 items in District 17 that I wanted to make sure that I went over. The first one that will come to you is case 2017-182. This is the appellant King's Interiors. This was deferred at the last meeting regarding, it's a variance regarding a 54 square foot staircase. It's a front setback. This was deferred in part because there was a question on the as-built. Basically, was it too high? The information I've gotten from zoning is they are still determining that, and they're still working through that. That, of course, is not before you. The front setback is before you, and so it is obviously up to the board to decide whether to take it up or not. This has been an ongoing conversation on the street. I don't quite, frankly, think we have a resolution right now, and so it's up to the board whether you want to try to take it up and take a vote on the front setback or not. I would appreciate a little bit more time, but I fully acknowledge that the issues that we are dealing with in the neighborhood on this particular property and building are not the issues that are before you today. They are tangentially related.
Board members, do we have an opinion about this? I mean, it sounds like you're asking for more time just in general, and this is kind of leverage for everything else too as well.
I think that'd be an accurate interpretation, Chair.
Does anyone have any objections? So John Michael.
Yes.
Councilman Sledge has possibly asked for this to be deferred one more meeting to meet with the parties involved. Kind of give us the history of the.
Yes, it was, yes.
Yes, the King's Interiors.
The background is as follows. The request before the board is a request for a reduction in street setback requirements. The board may recall that this exact property and this construction project was here not quite a year ago for a reduction in street setback, a variance from street setback requirements. At that time, however, what was presented to the board failed to account for, very simply, the steps up to the elevated front door. So what we have now in the field, which I would show if in fact this is heard today, is an an elevated front door that would require a tremendous leaping athlete to enter at this point. However, building out the appropriate steps, a square footage of, I believe, 54 feet in this case, would require a further reduction in the front setback beyond what had been previously approved by the board, which I believe was a reduction from 40 to 16 feet. This reduction would be from 16, where the footprint of the house is built, down to 5 feet. That's an overview.
Councilman Sledge has asked for a deferral. What does our board think of this? Okay. I see we have a motion. Or let's hear from John Michael, who's the applicant here.
Mr. Helmer is the applicant, and he's present. We would invite him forward
Please come
to
forward.
address the thought of possibly deferring this to a later date.
Yes, please come forward. Please take a seat and push the button and identify yourself and your address for the record.
Josh Helmer, 1071 2nd Avenue South.
Andrew Pilkington with Kings Interiors, 1071 2nd Avenue.
So you've heard the council person. Do you have any response to that?
I think the question, I guess, is how if we built the house too high. Andrew and I did our research when we first pulled the permit, and I believe we are under the limitations. I sent the as-built over to John Michael.
Yeah,
He's
I
been
guess
doing a
what
little
I'm
research on it.
asking is about, would you be willing to defer this for the next meeting to talk to the community and the council person?
I've spoke to the community. We've gotten the approval on the stairs. I've attempted to talk to the councilman. I've attempted to talk to the neighbor next door who
You say
seems to.
attempted. What does that mean?
I've left several voicemails. We've had one conversation about it. And what I was told is that basically, no matter how much support I get in the neighborhood, I have to have the neighbor right next to me.
Do you want to have us hear this case today, or are you willing to wait 2 weeks, is what I believe?
I would
the
like
chairman
to
is.
have the case heard for the stairs so we can build the stairs if you grant approval. If there's something else, I'm willing to come back to talk about it, but I would like to hear the stairs if possible.
Board members?
Well, I mean, if he wants to hear it, I mean, we should probably hear it.
It does not sound like there's been much interaction with the council person on this or the other issue.
No, but, I mean, if the applicant's willing to risk, losing the appeal, which, you always are, I mean, generally, when it's suggested that there's a deferral, we always hope to find a solution before it comes to us. We really don't want it to be adversarial.
I think we want the same thing. So, I mean, if deferring it, the 2 weeks will help, I mean, I'm not opposed to it. If we don't defer it and we are denied, I mean, then we do this all over again? Is that?
John Michael, what are the
situation?
rules of the BZA if someone applies for something that's denied?
If a variance request is denied, then there's a wait period of 6 months before you can file what is in effect the same site plan or the same project. We have had cases come back that were different site plans and different projects at a same property by a same developer. But if I may kind of get fact specific here, you got to have stairs to that door one way or the other. So it's a matter of you're going to be coming back with realistically the same site plan.
But John Michael, I think 81 people are moving to Middle Tennessee a day, and one might be Superman.
Possibly. Possibly.
So,
We've even worked with our engineer to try to change the stairs to a sideways stair.
but this is a perfect example, really input from the neighborhood and the council person, I think, would help all parties involved. And you're not going to agree on everything, I'm sure. But even kind of location, materials, all of that will kind of go a long way. And if you're a builder or you're living there, this may not be your last project here. And this person over here is a year and a half or 2 years into his first term in the council. So he's going to be around too. So,
That's correct.
Councilman Sledge, what do you have to say?
The appellant and I have spoken. I'm totally open to further conversations. We've had very cordial conversations. Chair, if I may say so, my comments have really been reflected as your comments. They've been the same content, so.
So it's your decision, but what would you like to do? Like I said, you could either hear the case today, as we discussed, bless you, or you can defer 2 weeks. And the point of deferring is to meet. Don't come back here if you haven't met with anybody.
Yes, and that's, we did defer the 2 weeks from, I think, what was it, July 18th?
Whatever the last meeting
Whatever the last one was. And I don't believe we've spoken.
I don't think
the
we've
entire time.
spoken since then, no.
And
But I don't think I've gotten a call from you in that time, just to be clear.
But even, he's here, so you
Yeah.
could.
But we could talk
here,
after
you
this.
go-
I'm very happy to.
Yeah, I mean, obviously, we need stairs to the front steps. It was an oversight. We had it drawn in. We thought plans were saved. It was only the site plan. Our surveyor made some mistakes of not including some lines, so we have a problem with that.
So what are your wishes then for today?
Chairman, if I may, if they think it would help, we could take this issue up later.
Oh, I know, but it sounds like from the council person, there's larger issues that involve other community members, not just, a short 10-minute conversation here at the BZA.
No, I would agree with that, Chair.
So that's where we are. You have the right to hear the case today, but, that person over here will probably speak against your stairs or today.
Yeah, and it's
Or-
tough because I think it's not even about the stairs anymore. The stairs were an open.
That's what we're about. We're about the
Yeah,
stairs.
exactly.
We don't have anything on our agenda but the stairs. But
push it back. It's safe.
All right, we'll defer.
okay. So, John Michael, they wish to defer. Do I have a motion to defer this to the next meeting? Is that acceptable? 2 weeks from now?
The 17th.
Okay.
So moved.
Second.
Okay. Motion's been made to defer till the 17th and properly seconded. Any other discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? It will be deferred till 2 weeks from today, and we will try to put it near the top of the meeting, so you will know where you'll be here. So what I would suggest to do in the interim, there's your council person over there, you could start the dialogue about this, and I'm sure he will say, come by at this place and time, and we will talk about these broader issues. And like I said, you may not find consensus on everything, but, the attempt of trying, and also maybe there's some smaller things you could agree upon, even kind of how these stairs go up or how they look or things like that. So,
Okay.
Councilman Sledge, do you have anything else to add?
Very amenable to that. We can meet right after this, if that's all right.
Okay, thank you.
All right,
John
thank
Michael.
I've got two more, if you don't mind, Chair, but they're very quick. Case 2017-192, this is the property at 438 Wingrove Street. As you will hear from the appellant, they are agreeing to build the sidewalk, so I feel comfortable. This has a pretty steep grade, this property does. So I believe they are not actually dealing with the sidewalk requirements, but they will come to you about garage door orientation and driveway. I feel comfortable with this moving forward. And then the final case that's in District 17, 2017-193, that's at 2304 9th Avenue South. It's the detached garage and accessory building. On its face, I don't have an issue with this. It being R8, this is a lot size that is much smaller than R8. It would probably be fine in a neighborhood that was R6. There has been more discussion, quite frankly, within neighbors of how this building has been used rather than the structure. So you may hear comments on that today, but I feel comfortable with whatever the board decides. So.
Any questions for Councilman Sledge? We appreciate you being here.
Thank
and
you so much.
We hope you talk to your constituents.
Absolutely. Thank you.
Okay. John Michael.
Thanks, guys.
Mr. Chairman, having heard from our attending council members and seeing none other in the room at this point, it's time to move forward with our consent agenda. For members of the public, we will note that the board utilizes a consent agenda. One board member reviews each of the cases before today's meeting and identifies cases where the appellants have met the criteria for their requested action. If the reviewing board member determines that presentation of testimony would not alter the material facts, then that case is recommended to the board for its approval here at the outset of the meeting. We will enter into the record those cases that have been so recommended, and if anyone is here in opposition to one of the three cases I identify in this list, please signify by raising your hand, make sure I see you, and we'll pull it out of the consent agenda and hear the case in its regular order. The three cases reviewed and identified for the consent agenda are as follows. First, case 2017-168. Sharon Piggott, the appellant for the property located at 2318 Woodmont Boulevard, requesting a variance from side setback requirements. Is there anyone here in opposition to case number 168? Seeing none, we'll identify the second case, which is 2017-185, Matthew Curley, the appellant for property located at 5909 Long Meadow Road, a request for a variance from side setback requirements. Is there anyone here in opposition to case number 185? Seeing no one, we'll identify the last case from today's agenda, case 2017-197. Jimmy Williams, the appellant, the property located at 1104 Stratton Avenue, Council District Number 6, a request for a variance from rear setback requirements. Is there anyone here in opposition to case number 197? Seeing none, Mr. Chairman, we have those three cases identified for your proposed consent agenda, case 168, 185, and 197. We would solicit a board motion at this time.
Those have been moved to the consent agenda. Is there a second? Second. Any discussion on the three items on our consent agenda? Seeing none, all those in signify in favor of the consent agenda signify by saying aye. Aye. Opposed? Passes unanimously 6-0.
With that, we'll remind members of the audience that that was your case or one of your cases. You are welcome to stay, but you have achieved what you intended to achieve. You can see zoning staff as early as Monday for helping getting the permits that you seek.
Thank you all very much.
And Mr. Chairman, we'll move to the first hearing. In fact, if I may, as I'm taking a seat, I know that the chairman had mentioned the potential interest in taking up the motion to dismiss, or also styled as motion for show cause, for case number 2017-181, an item A appeal that's set on a later docket for the Board of Zoning Appeals. But this preliminary motion is set to be taken up today.
Yes,
Given that there are lawyers representing both sides in this instance, the board may want to consider moving that to the top of the agenda.
Yeah, let's hear that first, since our lawyers are here and ready, and we will hear 181, the motion to dismiss.
And Mr. Chairman, as I guess the movant is Mr. White on behalf of the developer for the property at 206 Fairfax, we'll invite him forward at this time. Mr. Prochaska, I believe, is representing the item A appellants on case number 181. Although we've not got a formal staff presentation, the overview is that this is an item A appeal challenging the zoning administrator's interpretation of the applicable zoning laws pertaining to the proposed development at 206 Fairfax Avenue. This is just off of the area where 440 exits onto West End. It's an area you've all driven by hundreds of times, I'm sure. The appeal challenges, as I noted, the zoning administrator's interpretation of the applicable zoning laws. The item A that was subsequently filed is now being challenged with this motion to dismiss. I believe you have in your packet a letter or brief from Mr. White representing the developers, also correspondence from Mr. Prochaska representing the item A interest. So with that, given that the motion is filed by Mr. White, I believe we would hear from him first, and then, of course, responses from Mr. Prochaska on behalf of the appellants. Mr. Chairman.
Mr. Chairman, my name is Tom White, 315 Dedrick Street. I'm an attorney with Toon, Entricken, and White, represent the property owner in this case. As mentioned by John Michael, this is a motion to dismiss, and basically it's on a predicate of two issues. One is that the appeal was not timely filed, and secondly, that there's a vested right in my client's property pursuant to the Tennessee Vested Rights Act. I would ask for 2 minutes for rebuttal with the consent of the chair.
Yes.
Basically, on the Metro Code issue, what the Metro Code states at 17.40.260 is that the appeal must be filed within 30 days of the commencement of construction. There's no dispute here about the dates that we're talking about. There was a building located on this site, a daycare center, and there was a demolition permit and a building permit basically obtained the same day, February 27 of 2017. I'm going to ask to have handed to the board just a picture of what the daycare center looked like at that date. Under the Metropolitan Code section as referenced, again, it's clear that the appeal must be filed within 30 days of the commencement of construction. Our argument is very basic and direct, and that is you cannot commence construction without the demolition of the building that you see in front of you. That demolition permit, again, basically the same day as the building permit, February 27, that building was taken down and totally down by March 3rd of 2017. In other words, within a week of that being done.
Was there an actual building permit issued?
There was.
And so it wasn't just a demolition permit?
Both were issued. There was a building permit for the structure that's under way right now, and there's a demolition permit to take down that construction that's there.
And then, and on what basis does construction begin with that date? Because you said the demolition had to happen, and it's my understanding demolition and construction aren't the same thing. And so tell me, what day did construction start in your opinion?
Well, the construction, in our opinion, basically starts with the demolition of the building. In other words, it's our opinion that the, quote, commencement of construction, which is a decision which this board has to make, you cannot commence construction until and unless the building that's there is taken down. So in our opinion, the first step along that lines is the taking down of the building itself. That, in our opinion, is one of the items for commencement of construction. That work is completed by the date of March 3rd, or basically within a week. The second item that's not disputed is that there's a stone base that's installed on the site on April 19th of that year. And finally, there's a footing and column rebar work which has begun on May 23. Now, the day that the appeal was filed was June 21st. So basically, the, quote, commencement of construction would have to take place by May 21st.
So what is this stone base? I mean, tell me exactly what the stone base, in your opinion, was, and what does it entail? Who put it in? Was it underneath the, footing?
This is prior to the footings. It's something where you stabilize the site itself. The base is put down, common construction technique where that stone has to be put down to commence construction.
But is it underneath where the any of the buildings are going to be, or is it on the periphery, or where is the stone base?
The stone base is basically on the entire site. The stone base is on the entire site. It's delivered to the site. The same contractor that took the daycare center down, which is the facility I showed you, began the work immediately on the other. So again, by March 3rd, the daycare center's down and we began this additional work. It wasn't just the stockpiling of materials, but on that date of the 3rd, we began work on the site itself. Again, stone base installed April 19th. Now, our argument is that for commencement of construction, which is a decision by this board, you have to, in our opinion, include demolition as the inception of that process. You can't, quote, come vertical before you basically take the items down. That's the issue that we raise. But the other is, as far as the stone base by every recognition is April 19. Again, the appeal is not filed here until June 21st. So all activities prior to 30 days before then are critical. Those things are done. And again, part of the reason here is that you're trying to give notice that something's to take place on the site. What's in the record also is that the decision by the zoning administrator, Mr. Herbert, was issued on March 28th. So if you look at the sequencing of events, the building and demolition permits taken out basically February 27. The building is taken down within 7 days. You then have the stone base installed April 19. In the meantime, the zoning administrator issues a very elaborate decision and opinion about what was correctly the quote frontage for the property on the 28th of March. So it's clearly a discretionary call with this commission to decide, would people have been alerted that there was something taking place on the site that they should appeal? And it's not 30 days from Mr. Herbert's decision, which is March 28th. I'm not arguing that. But if you look at the equities of this matter, you have February 27 on the two permits being issued. Within a week, there's a demolition of the daycare center. You have the decision of the zoning administrator at great length, which is issued March 28th, and then on April 19, you have the stone base installed. And so our argument is that to anybody that you're trying to be fair to, how could they not understand that there had been a commencement of construction at least 30 days before that June 21 date, is our opinion. With respect to the second item which we raised, which is the Vested Rights Act, the General Assembly passed the 2004 Tennessee Vested Rights Act in the year 2014. It did not become effective until January 1 of 2015. Basically, under the Tennessee Vested Rights Act, the language is clear, and it's basically giving somebody who obtains a building permit a vested right to pursue that period. And in this case, the language says, and it's Tennessee Code 13.4-310, the vesting period applicable to the approved construction project for a building permit has been issued shall begin on the date of the issuance of the building permit by the local government and shall remain in effect for the time period authorized by the approved building permit. This building permit was obtained on February 27, and therefore, in our opinion, it's protected under the Tennessee Vested Rights Act. Our adversary wants to claim that doesn't apply here because somebody has the right to appeal the decision of the zoning administrator. In our opinion, that would basically totally circumvent the Tennessee Vested Rights Act.
So we've heard cases before where the zoning staff made a mistake, and this board has voted against the property owner because it was a mistake. And so how is that situation impacted? Because from what I hear you saying, that if the zoning administrator, because it's not often Bill who issues the building permit, I mean, it's the Metro staff member that sees it and they sign off on it. If that person makes a mistake, are you saying that there's no remedy, that they can build whatever they want?
No, I'm not saying. I am saying this. I don't know of a decision by this board since the Vested Rights Act came into place. That Vested Rights Act came into place and was effective January 1 of 2015. I do not know of a decision by this board where that argument has been raised or been decided. But
I haven't heard the argument, and it probably would have been raised, and I've been on the board a little bit long, so
Right.
I'm thinking of a case that had a 1,000-foot rule that wasn't met, and anyway, but they basically built everything, and it's like,
again, I want to be clear. It is the discretionary call of this board, in my opinion, to determine when construction has commenced. I think the Tennessee Vested Rights Act means what it says, and that is there was a permit issued. It was February 27. It's basically 4 months later before the appeal was taken in this case. So the members of the public who are watching and observing the site are aware that a building permit's been issued and a demolition permit's been issued. So as far as the equities of the matter, I feel very strongly that you've got the zoning administrator having met with a number of different people who issued this decision that he did of extreme length on March 28th. So you've got building permit February 27, which we think locks it in on the Tennessee Vested Rights Act, but then equitably, by that time, you've got the building taken down. So if you're talking about what's equitable here, what is equitable about somebody who wants to file an item A appeal, realizing that it was done on March 28th is when it was rendered. Secondly, they've seen the building come down 2 weeks before that, and they've seen this stone base applied to the site. That to me is the most equitable and compelling argument. And for somebody to wait, even by their count, maybe they feel like we beat it by a day or two, because what we've shown is that the footings and rebar were begun like on the 23rd of May, and they filed their appeal June 21. So to me, their argument is, if it's accepted, we got by the skin of our teeth. We filed 2 days before, after watching and being aware the permits came down. Commencement of construction has got to be in part the demolition and coming vertical with the stone base. So as far as I'm concerned, it is in part an equitable appeal to this board that if someone really wants to stop a project, and this is a significant project where there's a significant amount of money involved, in my opinion, under the circumstances we've got here, the best argument they can make is that we squeaked by here 2 days before, because everybody has always recognized that at a minimum, the footers and rebar are something that are commencement of construction. We had things well before that. That's our argument, and again, it is an equitable call by this board, but feel very strongly that it's hardly fair to somebody in the business world to come forward and put their money and time and reliance there.
How much of the building has been constructed?
At the present time, I can actually show you that. May I bring this up?
Mr. White, how would you describe it? I mean, show her, but just for the record.
Oh, thank you. This is a picture
Oh.
taken today.
Go over, yes, let's microphone so Channel 3 can.
There's additional photos.
you can, this shows the building significantly under construction, being framed. There's, as far as percentage of construction, it continues forward, but I would say we can safely represent approximately a third of the building is basically completed at this time. This, again, was a picture taken yesterday and shows on that and other pictures that are there next to it the appearance of the site, which was again yesterday. So I can conservatively say to the board at the present time at least a third of the building has been finished. And obviously there are ways where someone can seek.
Mr. White, when did that fence go up?
Mr. Chairman, I'd have to ask my client.
Okay. I want to say about March 10th. Can you repeat that, Mr. White?
Yes, if I can ask my client to come up for just a moment.
Truett Ellison, one of the owners at 206 Fairfax. I'd have to double check, but I believe the fence went up about March 10th.
Okay. It's a pretty tall fence. It's obviously a construction fence.
Yes.
And Mr. Chairman, I say that because you're aware of how specific Metro is about demolition permits and keeping the public off a site. That construction fence went up basically concurrent with the demolition because it was to protect the members of the public. So again, it's kind of hard pressed for somebody not to say they didn't realize construction had commenced when at a minimum the building came down and this construction fence
But
was
the fence is still up today, though, right?
It is partially up. It's totally
The
up.
construction fence is totally up today, sir.
So that fence is considered a construction fence, not necessarily the kind of demo fence that you see to, what's the term used, the mitigation?
This is not a silk fence.
Yeah, this is a construction fence.
This is a construction fence, and I comment
And,
that.
yeah, please look at the iPad again so you could tell us when that was put up.
Yeah.
So based on that photo or your memory, when was that fence put up?
Sir, I'm looking at the list from my project manager, and let's see. Oh, so, okay, May 10th. May 10th is when
Okay.
they installed the fence.
And again, Mr. Chairman, we can, I think these have been shown back and forth as to what was there in the pictures that are for the current site. But I wanted to mention, with respect to the construction fencing that's up there now, it's not just for the protection of the public, it's also for the safety of motorists that go close by to that site. And there's access coming through the construction fence, but it's only for construction traffic.
Okay. Continue, Mr. White.
Right. Basically, our argument is that of the items that you have seen, again, it's a decision by this board as to what is the equitable thing to do here. And you've got a fence up at the site, which I think can't be any clearer. And at that time, the construction has begun. You've got construction equipment on the site, and you've got a fence which is hardly a silk fence. It's for construction purposes. So it's our opinion that we would come within the confines of commencing construction well before the May 21 date, which is the key because the appeal here was June 21. And so, again, the position the board's got to consider here is what's the fair thing for the owner of the property? What's the fair thing for somebody that's driving by looking at it? Could they really come in on June 21st and say, we're within 30 days of the commencement of construction? I think that's extremely far-fetched. That's our argument, Mr. Chairman. My client, who's sitting here, is one of the owners of the property. He can answer any questions. I'll answer any questions, but that's our position.
Okay. Any questions?
Is construction continuing, or have you stopped work?
No, construction is continuing now.
And what will the building be?
It'll be a 21-unit apartment complex.
Any other questions for now?
Are the permits appropriately displayed on the job site?
Yes, sir. They've actually been on display since, I believe, February or early March.
On a pole? Where were they on?
On a pole, I could look for a photo, it'd probably take a while,
Yeah, well,
but they're actually on
Sure.
a presentation board.
sure. Any other questions? Mr. White, do you have anything else to add right now before you hear from
I
the
do
other
not,
board?
thank you.
Okay, thank you. Okay. We have your briefs and your responses, so identify yourself, state your address, and let's start.
Good afternoon. I'm Joe Prochaska. I'm a lawyer on behalf of Hillsborough West End Neighborhood Association. I'm also one of the individual appellants because this is just down the street from me. My address is 401 Church Street, Suite 2600, Nashville, 37219. That's my office address. I would like to note that as we were talking, our council member for this district, Berkeley Allen, has come in, and I don't know if the board would like to hear from her before it hears from me.
Council
or
Lady
how-
Allen can speak whenever she wants, so you're going to speak after he finishes. Okay, sure.
All right. All right. Well, I would like to address a couple of things. Well, there are two issues that we have here, is the timeliness of the appeal first, and then the Tennessee Vested Rights Act, and how that interplays with the board's ability to correct mistakes made by a zoning administrator or a building commissioner. Let me first tackle the timeliness of appeal, because you've heard some things said. We submitted this morning a supplemental response that contains my affidavit with pictures that I took. I apologize for the delay, but I did not know that the timeliness of an appeal was going to be raised until 3:20 yesterday afternoon. So that's why we have this. But there's I've got a very good timeline of pictures attached to my affidavit with regard to the site, so you can see what has happened with the property. Because the issue here is, did we file within 30 days of the commencement of construction? And construction under the Metro Code has a very, very, very specific definition. And that definition is physical improvements such as, but not limited to, water and sewer lines, footings, foundations developed on the site. That's construction. What is not construction is clearing or demolition, clearing, grading, the storage of building materials, or the placement of temporary structures, like a construction fence. That's not beginning construction. So when we look at what construction is, it is water and sewer lines, footings, foundations. Now, we know that we're within the 30 days from the footings issue. That's clear. That's admitted. That's not disputed. There was one thing, though, that was represented as being undisputed, but is actually in dispute, and that is exactly what was meant by this stone base. They said that this stone base covered the entire site. You may remember those words. If you can look at, I hope you have my supplemental response that I turned in this morning, and I've got a series of pictures that are attached to that starting on March 16, showing that there was a silt fence put up on March 16, and there was some gravel dumped on the site. Those are the first three pictures. Then I also have a picture of the site on April 14, actually two pictures of the site on April 14 showing the gravel having been smoothed out. And there's nothing vertical there. There's just the orange fence and a few stakes. That's on April 14. On April 20 and on April 27, I have additional pictures. And again, you look at that, and there's nothing vertical on the site. There are no footings, no water or sewer lines, no foundations. It's just some gravel. There's no stone base. It's just gravel, some materials, a silt fence, and some survey stakes. That's it. That's it. That continues on. I've got pictures on May 6th and May 21st May 21st has the first indication of a temporary structure, which is this fence going up. But again, it's still, the site's covered in grass. There's some gravel there that for grading purposes and for construction equipment to come in and out. You can see when you look through there, there is no construction equipment anywhere on the sites during any one of these pictures. There's nothing vertical. There's no stone base. There's some gravel that was spread and a temporary construction fence. So let's come back to what the definition of construction is in the code, and that is physical improvements like water and sewer lines, footings, or foundations. None of that occurred. None of that occurred. What did occur was clearing, grading, and the storage of building materials. But we know from the express terms of the code that that's not construction. So the construction did not commence until the footings were put in May. And our appeal was filed within the 30-day period after that. So this board should not unilaterally or, ex post facto shorten the time period for appeal. If it says 30 days, it means 30 days. One of the things that were talked about at the beginning were the equities of the matter. And Councilmember Allen can speak more towards this. But during this time period, there were attempts by the neighbors to have conversations with the developers about how this property was being developed. Those conversations did not yield any change in the building that was proposed. That's why we're here today. It's a 21-unit apartment building at the end of a residential street. This building that they're putting up is the 17th parcel of an OR strip that fronts on West End. And this is the tail end parcel of those 17 parcels. It begins with the Westboro apartment complex, goes by I think it's Team Nashville, goes by the Continental apartment complex, all of those. This is the last parcel in that strip along West End. And there's a 21-unit apartment complex that's being built using access primarily from the an alley that connects to Fairfax and Marlboro. But there were so let me come back to just the terms of the statute of the ordinance. We didn't start. We filed within the 30 days of the commencement of construction, and there was nothing going vertical.
I guess one of the questions is what took so long to? Why did it take so long to file the appeal? That I mean, it sounds like that. Why did it take so long to file the appeal? I guess that's the question. Because, I mean, even with Council Lady Allen, the letter, you say maybe it took a week for that to get to the neighborhood because, Bill put it in the mail, took a few days to process and gets out. I mean, you didn't appeal till almost 2 months later. Why did it take so long?
Well, it's my understanding that some of the neighbors were continuing to have discussions with the property owner. Those came to naught. Those came to naught. And it may not have any relevance at all according to your argument. I was just curious because if your argument is that it started the 23rd of May and you appealed within 30 days of that, and we did.
Their argument is different, and so we got to sort that out. I get that.
Yeah. Well, the pictures show you when, and one of the reasons why I do want that in the record is because the pictures show exactly what was going on at the site. It's not, you're not hearing words, you're actually seeing what happened, and that there was nothing going vertical. There was just clearing and grading. There was there were no footings, there were no foundations, there were no water and sewer lines being put in. There was nothing like that.
So I guess in item A, I'm always tough to know the appellant, who's the appellant, who's not. So Mr. White's case had two components. The first was the timeline, and if we agree with you on the timeline, then the argument is the vested rights Tennessee statute. And so would you address that piece too, to help us know how, from your perspective, we should think about that?
And remember, we're not all lawyers up here.
I'm not a lawyer.
Use small words when possible.
Boil it down and make it simple.
That's right.
Well, I'll do my best. And the Tennessee Vested Rights Act refers to building permits that are issued by the local government, all right, the local government. Elsewhere in the state, I don't want to get, I'm trying to keep it not too legal, but in short, plain terms, the Tennessee Vested Rights Act did not abolish the Board of Zoning Appeals. And the Tennessee, with regard to item A appeals, and the Tennessee Vested Rights Act did not eliminate the power of this board to correct mistakes made by the zoning administrator or a building commissioner. You still have the power to correct those mistakes. And the reason why is because even though they enacted the Tennessee Vested Rights Act, this is number one, they left in place the statute regarding aggrieved parties appealing the decision of a building commissioner or other authority to the Board of Zoning Appeals. So we still have that statute that gives us the right to appeal to this board. It's still there. If they had wanted to get rid of that right, they would have repealed that section.
We understand that part, that basically this is kind of a Marbury versus Madison argument. The fact that you're arguing in front of us today, we have the authority to hear this case,
Okay.
right?
Right.
But what I'm asking is his rights vested because of their construction and all the arguments? What's your response to Mr. White when he says, we have done all this construction and you're too late to the game?
Okay. Well, that's
No, he has his permit. He has his
right.
permit.
Yes, it is permit. It's the permit. It's not the construction.
Why isn't he vested? Because he has his permit.
Because the permit was not final by the local government. It was just issued by the building commissioner. The statute says local government. Elsewhere in the statute, it talks about permits being issued by the building commissioner. This is a technical argument.
So if I get a permit, it's not final?
It's always subject to an item A appeal. And if 30 days after construction commences, when you've gone vertical by putting in foundations or footings, then your permit is good. But the Tennessee, the contrary, or the flip side of that argument is that the Tennessee Vested Rights Act did not turn a local building commissioner or someone in the permit office into the sole and last arbiter of what the zoning laws in this county mean. Because, so you still have the right to correct mistakes that were made at a lower level. That's number one. Number two, we're not attacking his vested rights. His vested rights are to proceed with construction in accordance with the zoning ordinances and statutes that were in place when he got his permit. Okay? We are seeking to enforce those statutes. We're saying that those statutes were incorrectly interpreted. So we're not trying to amend the zoning ordinances. We're not trying to change the development standards that are set forth in the Metro Code with regard to this parcel of property. We're seeking to enforce them because they were incorrectly interpreted. So we're not upsetting his vested rights. We are seeking to require him to develop the property in accordance with the terms of the zoning ordinances that are in place. We're seeking to enforce them, not change them. The zoning administrator made a mistake in interpretation. This board has the power to correct that mistake. And
why did the zoning administrator make a mistake?
But that's not our.
Well, that's going to be for August 17th if we get to that point. But there are two.
But that's the point that you're bringing up, that basically you have a right to kind of raise that.
We have a right to come to the board when the zoning administrator makes a mistake.
Okay.
Or when anyone else makes a mistake, because we're seeking to enforce the laws, not change them. The Tennessee vested rights prohibits the Metro Council from changing the zoning of that property once he gets his building permit. We agree with that. What the Tennessee Vested Rights Act does not do, however, is take away this board's power to correct mistakes that were made by the zoning administrator or someone else in issuing a permit. And that's why I think it's 13.7.108 remains on the books. And for the lawyers on the board, when you have two statutes, you have to harmonize them to make them both effective. When the legislature didn't repeal 13.7.108, it means impliedly that the board still has the authority to hear appeals. And so I think under the, so we're here to correct a mistake, to enforce the ordinances as they're enacted, not to change this to an RS8 zoning, we're not trying to change the zoning of this property. We're not seeking to alter the development standards. We're seeking to enforce the development standards, and that's why the Tennessee Vested Rights Act allows us to still be here, to argue our case.
Mr. Prochaska?
Yes.
Is that correct? Okay.
Thank you.
I want to circle back to the stone on the site because Mr. White's argument on the timeliness seems to point to that as the beginning of construction, as the stone would be part of the foundation system. I don't want to put words in his mouth, but that's what I'm hearing, and we'll revisit this on rebuttal. So are you saying that the stone that is on the site at that April date, the 19th or whenever it was, is in no way a part of the foundation or part of the foundation system?
Well, it's part of the grading for the property. It was there to allow vehicle access. If you look at my Exhibit 6 and Exhibit 7 to my affidavit, you'll see some stakes that are put out in the first page of Exhibit 6.
Right.
And those stakes are where the building is going up. The stone is outside that building footprint.
So that was where I was getting to. Are you saying the stone is in no way in the footprint of the building?
Yeah, and if you go over to Exhibit 7, the very first page of Exhibit 7, you can see that the stone is outside the building footprint.
Okay.
So it was put there for grading and for equipment access, and possibly for erosion control, but it wasn't for the footing of the building. And presumably, if you look at, again, if you take a look at the pictures, even on Exhibits 2 and 3, you can see where the building stakes are, where the stakes are placed for where the building is going to go up, and the gravel. It's not a stone base. It's just some gravel that was spread out. I think and it certainly doesn't cover the entire site. On Exhibit 4 and 5 and 6, you see that the entire site is covered. The building site is covered by dirt and then grass as the spring progressed. So there weren't any footings or foundations being poured. There was only a temporary construction fence that was put up later in May, and that's going to go away, and that's explicitly not. That's a temporary structure that doesn't constitute the beginning construction.
Thank you.
So, okay. So, and then the last point that was addressed was about the equities that was raised. And the two arguments that the owners are making are very legalistic. I don't know that equity really comes into play for either of them, but I'm going to address the equities of the matter anyway because it's of concern. Construction is racing forward at that site right now. And I use the term racing because it's, the neighbors have complained, and Council Lady Allen can speak to this, that construction is starting before 6 a.m. in the morning, and it's going on the weekends. So they're racing to put this building up. They absolutely are. The other part of the equities is that as someone who has been active in my neighborhood association for decades and has had and has represented owners and developers of properties before, when you're going to when you're coming into a neighborhood, you want to meet with the neighbors. It doesn't matter if it's commercial or residential. You want to sit down and talk with the neighbors. And that really didn't happen here. And Council Lady Allen can speak more towards how that happened. There was no give and take. There was no sit down to try to work through items or work through issues with regard to construction on the site. It was just a by right construction. We have, we are able to build this building by right, so we're going to go forward and we're going to do it. Neighbors be damned. So that's unusual. That's very unusual in my experience. So if we're talking about equities, I think that needs to be considered as well. Those 2 points need to be considered as well. I just want to put those 2 points out with regard to the pace of construction and then the lack of communication with the neighbors.
Any questions or other questions? Do you have anything else to add?
No, Chairman.
Okay. We are going to hear again from Mr. White.
Mr. Chairman, if you will, basically, the issue is, here are the items that took place before May 21st. The demolition of a very significant building took place. I can't fathom somebody saying that's not a, quote, commencement and a flag to everybody that construction is beginning. That took place and was through by March 3rd. Again, the key date is before May 21st. There's stone on the site. They want to claim that it wasn't there for the footings. It's called lay-down stone. That's what you utilize to get your construction equipment in on the site. That was clearly down long before the 30 days elapsed. The next argument they raised is they ignored
You said it's lay down to get your construction equipment on the site, but what does it have to do with the actual building itself?
It's really the prep of any site, if you will, Commissioner Taylor, where in order to have your equipment on the site and not cause a real site issue with respect to dirt and other things like that, you put up the silt fencing and you put the lay-down yard on there. And again, the argument that's being raised here is that unless something's vertical, it doesn't count. That's not what it says. The argument has been repeatedly stated here today, and it says commencement of construction items such as, and it goes through water and sewer and other items. It doesn't say you have to become vertical. That's their interpretation. Water and sewer aren't vertical, period. But their definition today is it's got to be vertical. And the lay down of the gravel on the yard, which is pretty extensive, you can see in the pictures, is what you need to do to stabilize a site to begin the work. And again, it's not just the grading of the site, it's the foothold, it's the base on which you bring your heavy equipment. That clearly took place within the appropriate time frame. And with respect to the arguments about what took place on the site, you raised the fact that for whatever the equities are here, that the zoning administrator did an exhaustive memorandum that went out on March 28th. We were told maybe that was out like a week later to everybody. That's what I heard here today. So let's talk about...
I was just speculating that if it even was a week later, then I have no idea when anyone received it or it got spread to anybody else. I didn't want to imply I knew something.
And we don't either. We don't either. We just know that we stepped forward in good faith. That decision was rendered. And there was a time where voluntarily we discontinued work on the site to wait and see what the zoning administrator was going to decide. So frankly, with respect to the argument of the equities, I find that just incomprehensible that somebody's going to sit here before this board and say that we did not talk to them. And I'll stay here the rest of the day if this attorney wants to say what their proposal was to do on the site. I'll wait because there was seriously dialogue that took place between my client and others as to what might take place on the site. And if there was a specific proposal that they would adhere to, which is their equitable argument, I'd like to hear it today, because it was never put on the table, never. So again, the issue today, though, is what has been mentioned with respect to what took place on the site. And again, I don't know a case that's come before this board where you had the demolition of a building of that size as a total commencement of construction. That had to come down before you went vertical. The fact that it came down ought to count. The other thing is the Tennessee Vested Rights Act. If their decision and opinion about the Vested Rights Act is correct, then the Vested Rights Act is meaningless. You can go get a building permit, and under their interpretation, if you appeal an item A case or you file a declaratory judgment suit, it's meaningless. Nothing's over until they have finished an appeal. That's not what the Vested Rights Act. It says, and I'll read the language one last time, quote, "The vesting period applicable to an approved construction project for a building permit has been issued. It shall begin on the date of the issuance of the building permit by the local government and remain in effect for the time period authorized by the approved building permit." Now, what they're trying to argue today is that we're saying that they can't change the zoning laws during that period of time. It's far broader than that. It doesn't say zoning. It says you can't change any of the local requirements, period. Not zoning. It's not zoning. That's what happened historically. Someone would start on a project and they downzone it. That's not the point. The Vested Rights Act says you pull a building permit, you have a right to rely on it. And if they wanted to file, their opinion is if you file either an item A case or a declaratory judgment, that it's not vested until it's all over. That guts the Vested Rights Act.
So the question, the question I guess is that if someone did pull a building permit and it was legitimately made in error, what happens?
My opinion is, we all get to speculate. We're not talking legalese here totally, because nobody knows. There's only been one case to my knowledge litigated about vested rights. That's here in Davidson County. But in my opinion, I think the Vested Rights Act trumps anything else. And if it doesn't, it's meaningless because it says you can't change local government regulations. Their decision is, it's just an interpretation call. So if you go through an item A case, as we're doing right here, and this board makes a decision, and then somebody appeals that to writ of certiorari in the Chancery Court, are they saying there's no vested right in the property until the entire process is over? That turns it on its head. Again, their argument is you have a right to look at it and appeal the decision of the zoning administrator. In my opinion, that can't be correct, because if that's the case, the State Vested Rights Act is meaningless, because the next thing is a writ of certiorari filed within 60 days to the Chancery Court. And if that's the case, there's never a vested right till that's over with, and it goes to the Court of Appeals. The whole point is you have a right to rely on what's in place at the time, and that's what we did. And if you remember, the building permit was issued February 27th. The zoning administrator made his decision basically a month later. And by agreement, we ceased activity on the site and continued to talk with people, including the council lady who's here. That's our opinion. We think that under these circumstances, I don't know how you can say that the demolition of this pretty significant daycare building is not the commencement of construction. The stone on the site, which maybe is not for the footers, but it's laid down stone of significance, the construction fencing. And their argument is, no, we beat it by 2 days. They didn't start the footers till the 23rd, and we filed on the 21st. There's, in my opinion, no equities on their side at all, period. The law's not there, the equities are not there. We respectfully submit that this matter should be dismissed.
Questions of Mr. White? Let's hear from the district representative, Councilor Berkeley Allen.
Very much. Good afternoon. Thank you for your service. I know how many hours y'all spend preparing for this and being here, and appreciate all the folks that have spoken. This is a complicated case. I had a conversation with Mr. Ellis in January, and he was at that point, I believe it was January, looking at doing something on the site. When we talked, he was thinking maybe 12 to 13 units, and I agreed that at that end of the street, Nashville Next says density on the corridors, that seemed like a reasonable thing to do with that property, and that we would continue to talk as he developed his plans. And my expectation would be continued conversation. And again, in his understanding, he's doing what he's allowed to by right, so he's not necessarily obligated to have a conversation with the council member when he does by right. Many people build things without ever contacting me. But the next communication I had regarding the property was a call from a grumpy neighbor saying, what's being built next door? I hear it's 21 units. And I said, oh, no, that can't be right. I talked to the owner. We talked about 12 to 13. And so when I looked into the information, discovered, yes, that was indeed what was happening. And we had sort of missed our opportunity to do community engagement that usually happens when a major development happens in a neighborhood. And that's unfortunate, because if you catch things at that point, you can have a conversation, you can talk about concerns, and hopefully reach some compromises. I did have some meetings with the zoning administrator and the owner and legal counsel, and we talked about the setback issue, which I hope will be discussed on August 17th. It was somewhat complicated how that should be interpreted, and it hinges on where you decide the frontage of the property is. And my hope was that if there was some interpretation that needed to be done there, perhaps there was some room for compromise to perhaps bring the building down from what the architect considered to be the highest and best use to something that seemed more in scale with the neighborhood. That never materialized. We had some good discussion, but the design basically ended up staying the same, except for shifting forward 10 feet to actually match what the setback requirements as interpreted at that time were. So at this point, I have been fielding comments from unhappy neighbors who feel like this process happened without their input, which theoretically, building by right can be done, but as Mr. Prochaska said, certainly things like this work better when there's communication. And I am frustrated that we were never able to sort of catch it at that point where it made sense to have a meeting. Maybe that will happen in the future. I can hope. So where we are today is after those meetings were held to talk about setback, the permit was put on hold, and they did stop construction at that point. The zoning administrator issued his appeal. The neighbors and the lawyers in the room who understand things like that said at that point, we disagree with this. We think it should be done differently. And therefore, we've gotten to the situation now where the neighbors, through their very capable lawyer, have filed an appeal asking that we go back and relook at where the setbacks actually should be measured from and how they should be done. In my understanding, the building then is proceeding at their own risk, and the fact that something has been built is immaterial. What it all boils down to at this point is how the people who understand the law interpret that, and I'm not even going to begin to try to address those issues. I think the lawyers have done their opinions very capably on that, but my hope is that we can continue to look at this process. I think there's still a possibility of making some adjustments, and that it can be something that addresses the current concerns of the neighborhood, which largely deal with density and traffic and where all these cars can park. And I would ask that we be able to move forward, that you not stop this motion, that we continue to have the meeting in August, so that we can perhaps finally get the parties together and have a conversation. Thank you for this opportunity.
Questions for Council Lady Allen? Okay. Thank you.
You're welcome.
John Michael.
If the board is satisfied with what they've heard from the movement and the respondent, then you have the opportunity to deliberate and take action on the motion to dismiss.
Okay. Are there any other questions? Let's close the public hearing and start discussion. So this is a motion to dismiss, as we've discussed, and you've heard from two very capable lawyers who are very familiar with real estate law on both sides of this. And it comes down to vested rights, permits, and, what is the start of construction?
The timeline question may be may or may not be the easiest one to tackle, but if we agree with the property owner that construction started sooner, then I think we have a timing issue with the appeal, which may impact that. So I would like to talk to our attorney and get your opinion on, or thoughts on what it means to actually start construction. And, understand that when you have language that says such as water and sewer, foundation and footings, that opens it up for other things. But, and I will say I'm a little troubled by the whole concept that you can wait this long to appeal, but I also think that starting construction is maybe fairly clear, so I'd like to hear your thoughts.
Counselor, what do you think?
I think the code is clear with respect to what construction is. It's been read a couple of times, but I'll read it again just for
Yes,
the record,
please.
since
Thank
I'm the one you're asking right now. It says construction shall mean physical improvements such as, but not limited to, water and sewer lines, footings, and/or foundations have been developed on the site. Clearing, grading, the storage of building permits, or the placement of temporary structures shall not constitute beginning construction. I think the issue before you today that has been raised is whether or not the demolition is sufficient to meet that definition of construction. I believe historically, by codes, demolition has not been treated as the commencement of construction because, and I would agree with that, because it says clearing, grading, and the storage of building materials. I don't think you can clear a property until something has been demolished, so I don't think you can say that clearing doesn't count, but that demolition does.
Can you read the first two sentences again? Because I think the other counsel left out the limited to.
It says construction shall mean physical improvements such as, but not limited to, water and sewer lines. So certainly.
But not limited to brings in other things that aren't specifically mentioned in the.
Correct. And so I think that because demolition isn't specifically mentioned, that's something that.
Or other things like fencing or gravel or whatever.
Yes, I think that it does say clearing, grading, the storage of building materials, or the placement of temporary structures shall not constitute beginning construction. So I think anything that you're looking at to determine if it meets the definition of commencement of construction, it can't be anything temporary. So I think it ultimately comes down to whether or not the stone base, if y'all determine that would be permanent. And I'm a lawyer, not a construction specialist, so I don't know.
I would say that, when we're, a lot of what we've been talking about, if you take demolition off the table, just for argument's sake for a moment, when we talk about construction, I think the general, or the conventional wisdom may be that, construction is an additive process. You do this, then you do that, and you do that, and you do that. Thus, vertical, whether you take vertical literally or figuratively. However, beyond the grading and the cleaning of the site and the preparation of the site, there's one portion of building that often requires taking something away, and that's you have to dig the foundation. You have to make the hole to add to the site. So it's the one thing that is not additive in the process. You are so laying out where the footings are, digging the trench for the footing is in and of it may be considered part of the site by the casual observer, but I would argue that it's actually part of the building process. Even though it is not additive in nature, it's something that must be done so that the additive, the adding of the footing can be done. You can't do it without digging the hole. You got to dig the hole to fill the hole. And that's the whole point of a foundation, is that what's there can't be built on, so you have to take away what's there to put something back in its place. So that's kind of where I land on the foundation argument and the such as.
I don't think we saw that in the photos.
Yeah, I think
possibly not.
If there had been a hole dug, that would have, I think, made at least it a lot easier and clearer.
Well, we don't have any pictures of the foundation system. I don't know if more rock was added and then foundations were built up. I think that's unlikely, but we don't have any testimony, whether there were piers sunk, if there were piles driven, if a spread footing was laid. None of that's been discussed. The only thing that was offered was that this gravel was laid. And it's I grant you a tenuous argument that stone was part of the foundation, but we don't really have any conclusive evidence that it's not part of the foundation.
I don't think it is.
part of the foundation. Usually it's a 4-inch stone base, and it does cover the entire construction site. It looks like they are building the entire site from the photos, and that was only covering part of a site, and it's not a 4-inch deep base that would normally go under a slab.
I don't disagree with you. I don't think we have any evidence that it's not part of the foundation.
Can I ask the board members, do we have a consensus on Metro's opinion that construction does not begin with demolition? Are we in agreement that those are two different things? And I would say my opinion is, with all due respect to Mr. White, that I think they're defined differently. It's two different permits. I do not think, though, that demolition is the same thing, and that's Metro's opinion. Do we all sort of
I agree with that.
agree on that point?
And grading is a separate permit as well.
Yeah.
Okay. And so if we agree with that, then is the argument or the discussion that we're having whether or not whatever occurred, the argument from the homeowners association is that the footers were the construction, and that's the date they started. Are we all arguing?
I don't
that way
necessarily
we are?
agree with that, with the fence and the stone and the other things preparing, and starting to really build on that site.
So you think the preparation
Well,
part-
they put up a fence, they put down stone, that was construction, preparing. I mean, they were starting construction when they put up the fence, they put down stone, that's
I don't necessarily disagree. I'm just trying to get where we're kind of formulating our discussion. And so then the discussion is among us, do we think those things count as is there a difference between, is there a hard line on the day construction started? And if so, are we making that determination? Because we have to determine if this appeal is timely.
Sure.
And so then we're talking about the fence is one thing, the stone is one potential event. Is there something else?
Because the
that
stone
was
and the fence had
outside?
nothing to do with the demolition.
Well, my question is there anything outside that 30-day period that we're looking at that should have been the triggering date of construction beginning? If we're looking at the timeline.
What was put in evidence was the fence and the stone. So,
And the fence we don't have a date on the fence.
So I guess that,
he did.
The fence was May 10th.
yeah, I'd like to, do you have a thought on,
In May, yes.
Fence is a temporary structure, in my opinion.
well, and I'd ask our attorney.
I think the definition of construction turns on, well, with respect to the fence, I think it could be fact-specific. If the construction fence is a permanent physical improvement, then I think it could meet the definition of construction. But per the code, the construction shall mean a physical improvement. So I think if the fence is a physical permanent, and then it also says that temporary structures are not part of construction. So I think if the construction fence in this instance is a permanent physical improvement, then potentially it could meet that definition.
And can I just step back one step, because I think myself into great confusion. And the timeline does bug me. I mean, it really, because you have on March 28th, the zoning administrator, has said, hey, this is what I think about it. And it took a good long while to get an appeal. And so, and we often say we're appealing the zoning administrator's interpretation of the rules, which came down on March 28th. But in this case, the appeal is the issuance of a building permit, and the building permit starts at construction, which is why we're still here looking at this timeline. Did I boil it down correctly? I mean, the timeline by all accounts starts at when we determine construction is.
Correct. With respect to again, it says.
The ability to appeal.
Right, the ability to appeal, because it says, 174260 says that the approval of a final site plan by the zoning administrator may be appealed to the Board of Zoning Appeals by a non-applicant within 30 days following the commencement of construction as defined by 1704030, which is what I just read to y'all.
And so if I got a building permit, and I do have a pretty good while before I actually have to start construction, right? In that, like a year or something? 2 years.
Actually,
And so there is a pretty good reason to say, just because I have the building permit, I mean, there are countless dead projects that we have voted for that, have long expired and never had any. We wasted a lot of time on a lot of
And they
hopes
come
and
back
dreams.
sometime even after 2 years.
But I guess that's part of why the construction piece is important, because it is, I might get a building permit and a year and a half later start it, timely to the building permit, but all of a sudden the neighbors say, oh, wait a minute, what's going on?
Right, and I think we're kind of starting to get into the vested argument. And in my opinion, the Vested Rights Act does not preclude an item A appeal of a permit if that appeal is timely filed. So then you look to what are the metro requirements of a timely appeal, and that's 30 days within 30 days of the commencement of construction.
and, Mr. Taylor, here, let me see if this addresses your concern about the timeline. I'm not convincing one way or the other. I'm just talking out loud for us because this is complicated to me. But actually, what the building permit says is you have to begin work within 6 months. It doesn't say construction, it just says work. You have to complete the project in 2 years. So theoretically, they could have done nothing with the property, and our appeal is not triggered until they actually start construction. So, I mean, they could have had the permit for 18 months and then started construction, and then our appeal is triggered. I mean, that's just how that works. And it does seem like a long time, but I do think that in this situation, it seems to me because they're not appealing from the zoning administrator's letter, that's not where it lies, they have to look at when the construction started. And we don't have a lot of guidance. And I will also say, when you look at the Vested Rights Act, they define construction and site preparation, and it's different. So, there's really a conflict to me between those statutes. But I think but if the question is whether or not the appeal is timely filed, it seems to me that it is. And if it is timely filed, then I agree in looking at the Tennessee Vested Rights Act and it specifically says it refers to a local government. It doesn't say where the zoning administrator makes a decision. It says a local government, and I think that would include us. So I'm leaning toward saying that the appeal is timely filed and we don't have to go, and the Tennessee Vesting Rights Act does not apply, but I'm open for a lot of discussion on that.
I would like to also say that we hear appeals all the time on structures that have already been built. So I don't feel that this case is any different.
Yeah, I'm tending to agree. And frankly, if the appellant has a right to appeal this long, then that's the appellant's right to appeal this long. There is something that that resonates with me on the other side to say, well, when would you ever start, a major project and have an investment of this nature? And I get that, but I do think that if we believe that construction starts when, a sewer line is dug or some physical improvement is made, then that happened at 5/23, then I think that this may be a timely appeal. So.
Well, I don't think it's a timely appeal. I think construction started when the stone was laid, and I have a problem with someone getting a building permit on February 27th and then going to the zoning administrator and having a ruling on the 28th, and them starting construction, and then us pulling back and saying, oh, well, you're still under your appeal period because, and I think that's what vested rights are all about. I disagree with the lawyer representing the neighborhood who said basically, you could appeal anytime, basically, that, once you get your permit, you've got 30 days to the BZA, and then you've got all these other places to, you could overturn the zoning administrator. Your permit has to mean something. You cannot always be under some sort of, oh, you have your permit, but you still, don't wait to start because, you could have all these appeals that, as Mr. White said, can go all the way up to Court of Appeals.
So I guess the question is though, like, again, back to the case where let's say I got a building permit and I went off and that day got my permit, started to build my garage or whatever it was, and it was, a complete error. I can't think of the hypothetical, but it was a complete error.
But we're not talking nothing came up in the testimony today that talked about error. We're here to talk about vested rights and period of construction starting.
But structures have been built.
But I guess I'm just saying was that what if I had a right to, through that permit, to build a garage, and the neighbors said, wait a minute, this is, what remedy would anyone have after the issue of that building permit to do anything?
But that wasn't in front of us today. That wasn't in front of us
But
today.
it's related.
Well, I think it's the exact same
related.
thing, because what they're saying is that, the vested right piece, I think it relates, because that's what I hear on one hand is, the second that building permit's issued, then they have a right to build 21 units.
Well, the same thing for Metro. Metro has a place to raise their concerns in a timely fashion, and if they don't, they're precluded from doing that too.
Well, I agree with you on it doesn't feel timely. It may be legally timely, and I think that's the other question we're talking
I
about.
don't think it's legally timely when construction.
Well, I know that's what, I get that was what you were saying, and that's kind of what the debate is, but, and I respect it, and like I said,
I think what happened in this situation, they thought it was going to be 12 or 13 units, and they were fine with that, but they weren't fine with the higher number, and then they're like, oh, well, now we need to do something. That's what happened. And, construction had started.
Well, like I said, I will not disagree at all that it should have been done sooner, just out of a sense of fairness, but out of a sense of law is just what like I said, I'm not a lawyer.
I agree with you.
And that's
why we have the Tennessee vested rights. It's about honoring permits, and there's a procedure in a timely fashion, and once you've started construction, you just can't, rip the rug out from under these people when they've started building and constructing.
Can I bring up a point here? It's 2:45, and I think this is maybe the second case we've heard. Right, correct. And there's about 10 of them?
Yes.
So I'm hoping someone will make a motion. I don't mind making a motion if you guys are ready. And I'm not exactly sure how to make the motion, but I just want to say I think we should hear the item A appeal. Is that a proper motion?
That would be motion to deny the motion to dismiss.
Okay, so
I will
basically,
go with that.
and the legal effect of that, John Michael, is what?
You'll hear the case in its entirety and in its substance on April 17th, 2017, if Ms. Carpenick's motion passes. Sorry, I said, yes, August 17.
And it basically denies all those arguments about timeliness and et cetera, correct?
Well, couldn't they bring all those arguments, or could they can bring the vested rights argument back, couldn't they?
Correct.
Okay. There's been a motion that's made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. We want to see hands. Opposed? 4-2.
So the motion to deny passes. Therefore, the motion to dismiss the item A appeal fails. The case will be docketed appropriately on August 17th, 2017, likely somewhere near the top of our docket. That'll bring us to our next case, unless the chairman thinks this is an appropriate time for a quick break. Very well, we'll take a quick recess and be back shortly. As we reconvene, case number 191, that's involving the property at 1009 A and B Shadow Lane in Council District Number 6, is being deferred to a later date, namely September 7th. That's a two-meeting deferral, and therefore that case, number 191, will not be heard today. We'll take up the first regular zoning case of the day, which is case number 2017-184. It involves the appellant Natalie Hannigan, appellant and owner of the property located at 1315 Stainback Avenue. This is technically an item A appeal involving the zoning staff's denial of a short-term rental permit. The applicant operated prior to obtaining the legally required permit and appeals the denial of the permit application today. If Ms. Hannigan is present, please come forward. Is there anyone here in opposition to case number 184? Okay, seeing no one, Ms. Hannigan, you'll have 10 minutes to make the desired presentation to the board, however you'd like to use that 10 minutes. And feel free to introduce yourself by name and address and make the desired presentation.
Yes. Okay.
I'm Natalie Hannigan. I live at 1315 Stainback Avenue. This occurred because I was advertising before I got my permit. It was a complete mistake. Like, I did not understand the legalese, and I have dropped the listing and halted all of that, put my sign up, paid my fees.
Okay, let me ask you a few more questions. So how long have you had this house?
3 months.
3 months, okay. And so when did you decide, hey, short-term rental is going to be a great thing for me to do?
Pretty soon, honestly, while looking at it, it has like a rooftop, like downtown view. Like, I was like, this is something I could look into.
So how did we not get a permit? How did you not get a permit?
My husband's grandfather passed away right after we bought it, so we went to Canada, and then I got sick, so it just kind of fell to the wayside for a minute.
So
Do you own this home? I mean, do you live in this home? Is this your primary residence?
We're moving into, yes.
So you rented it without the proper permit. How many times did you rent it?
Didn't rent it, only promoted it.
Oh, so this is one of the cases that, so.
As soon as I saw-
So everyone watching at home, it's not just renting.
Nope.
Just posting is a violation of our law that was passed by the Metro Council. So if you just post it, even if nobody rents it, that's a violation. So did you have any people that had signed up for it?
I had inquiries,
Inquiries, but no
and then I
sign-up.
dropped the listing.
So how did you know you were now in violation? Who
I got a
contacted?
notice from Robert Osborne, is that
Okay.
right? Yes, and I contacted him as soon as I saw that.
And then you
And I
just
tried to get the-
immediately pulled it down?
Oh, yeah. When I talked to him and he said, pull it down, I'm not playing.
Okay.
So it does look like it shows that there were dates blocked out, so that you did have folks that,
We had friends and family stay. That's all we had at the time.
and
Did you charge them?
No.
so, and I guess the only other question is that, so you said this is going to be your primary residence? And so, but you advertise in the VRBO that the home sleep's 20, that's also, I think, illegal too, right?
Oh, the number, sorry, that was a slip of hand. I meant 12.
Right, but it says 20 in two places, and it has 4 bedrooms with 6 queen beds total, I guess, is that, so that was, you're saying it
It's
would be
4
12?
queen beds and like 4 pull-out couches.
Okay,
We were just going to stay in one of the bedrooms, depending on how many they were going to have.
Any other questions? So you're here, so how do you feel about being in violation of law, and what do you want us to do?
I would like to never do that again. I would like to pay my fines, make it right, and then get a legal permit before anything else happens going forward.
Okay, thank you. We're going to close the public hearing. Discussion. So to remind everyone, once again, the short-term rental permit, you're in violation if you post an ad and you don't have a permit. Whether someone rents it or not, that's one of the trigger violations, but just the fact that you post, even if nobody stays there, is a violation of the law. So that being said, we have the authority to let the year stand, so that's normally the punishment, or do something less than that. Board members.
I think it's definitely a case where we would do something less than a year. It's a pretty standard situation. I think she did what we have asked people to do, which is to immediately drop the post. She had not already rented it, so she didn't have any reservations to cancel. But I think it's a situation where we would allow her to have her permit granted.
When?
I would say today going forward.
What do other people think? Is there a motion?
I forget the motion.
To basically, you uphold the zoning administrators that she was in violation, but we have now.
Yes, I move that we uphold the zoning administrator's determination, but that we grant her ability to receive a permit today.
To apply for a permit.
I'm sorry, to apply for a permit today.
Okay. Motion has been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. So this is what we ruled. We ruled despite that you've advertised without having a permit, you came to us and we allowed you, because you took down the ad, you seemed pretty contrite about doing this. So now you are eligible to apply for a permit. And I know you will do that before you rent or post in the future.
Absolutely.
So you know the procedure. If you don't know the procedure, we have a wonderful website about short-term rental. So good luck and thank you.
Thank you, ladies and gentlemen.
John Michael.
Mr. Chairman, the next case to be presented to the board is case number 2017-186. The appellant for the property owner, Red Group LLC, is Baker Donaldson, specifically represented by Mr. Joey Hargis. The property located at 2507 A and B Solon Drive over in East Nashville, Council District Number 7. The request before the board for this property, shown here in the highlighted sections for the proposed HPR development, is for a variance from the single driveway requirements and the driveway/parking area width in the contextual overlay district. Of note, this is an R10 zoning district, but the base zoning is less the issue here than the contextual overlay district itself. The proposal would allow construction of 2 driveways for the 2 single-family homes. Comes to the board under 17.36.470 of the Metro Zoning Code, which is the section that kind of spells out the particulars that are required under contextual overlay districts. Is there anyone here in opposition to case number 186? Seeing no one, that will be 10 yes. Mr. Hargis wished to address the board here at the outset, I believe.
Just clarify the record. The property owner here is not Red Group LLC. It is Professors Partners LLC. My clients purchased this back in the first part of, I'm trying to remember the actual date, but I've talked to the assessor's office. They're a little slow on updating their records, but just for purposes of the record. Also, too, I have a gentleman here from the neighborhood group, and he's what? Meredith, if you like, please.
Are you in support?
Come on. Join me.
Yeah, come on down.
We have been talking.
And please identify yourself for the record.
Yes, my name's Joey Hargis. I'm the attorney of record with Baker Donaldson, 211 Commerce Street. Our clients were issued a permit on this property, unfortunately an error, and we've been working with the neighborhood group to come up with a compromise, and I'm actually giving him a copy of the site plan we talked before the meeting.
Before we get started, Joey, John Michael, can you briefly go over the contextual overlay in this single versus double driveway issue and why this is even an issue?
To the extent the question why it's an issue is a public policy question, there are probably people better served in terms of speaking to that, like council members, than I would be. However, it is a requirement for an HPR, 2 single-family home development on a lot like the one here at 2507 Solon. There will be 1 driveway rather than 2 separate curb cut and driveways built in. That's a requirement. So that is one of the variances sought by the appellants here today. A lot of times the cases that come to you in contextual overlay districts have to do with not only the question of 1 versus 2 driveways, but also the driveway width or the width of the paved impervious areas at the front of a structure like this. Frequently we see 2-family development. Frequently there's the question of, well, where am I supposed to park? And if I have limitations on the width, how do I manage this or that other aspect? So we see cases come to the board every now and then, and doubtless you'll see more to come in the years to come, because this is a somewhat newer type of overlay relative to the other overlays under 17.36 of the zoning code. Mr. Hargis, I'm sure, will be best equipped to explain the nature of the request here today and the hardships associated therewith.
Okay. Mr. Hargis, let's go.
All right, Chairman, thanks. This particular situation is a unique situation.
And to my right is Mayor McKinney. Thank you. Mr. McKinney is the Vice President of the Neighborhood Association. We've been talking with them. These permits were issued by the Codes Department in error. Our clients, not making a vested rights argument here, but they were issued permits, no notation of overlay through their due diligence, both surveyor, real estate agent, all through this. There was clearly an error that occurred here, and there was no notation on the property that there was any overlay. So my clients began construction of what was done, and then were hit with a stop work notice and then approached me to say, hey, what's going on here? One of the discussions we've had with Neighborhood Association as well, we are requesting 2 driveways on this, given the topographic hardship that's here and the stormwater runoff. What we're proposing, I've passed before you, are our revised plans. So what our clients have done is we've revised it from the permit, the size down to conform with the overlay, the height to conform with the overlay. We are asking for 2 driveways because of the situation, what we'd like to avoid occurring, that is occurring, it has occurred previously by the prior owners, Red Group, is stormwater runoff from this property to the neighbor directly across the street. So our proposal is to amend our site plan to reflect permeable pavers at the top of the parking area to provide parking spaces for those, and then grading the property such between the 2 driveways to create that permeable berm which you see, which would channel the water runoff up to the center of the property here, and between the 2, hopefully alleviate any stormwater runoff issues.
Okay, let's hear from the Neighborhood Association person. Please identify yourself and your address.
Okay, turn on, cool. Justin Merritt McKinney. I live at 2430 Solon Drive, so just right up the street.
And we have an email from you. Thank you.
Yes, exactly. And it might be kind of strange. I'm actually the person who got the stop work order. And also I want to correct, I'm not actually an officer on the neighborhood board right now. I'm a past president of it, so I don't speak on behalf of the Neighborhood Association, but I do speak on behalf of other people who were involved in the contextual overlay. I was one of the people who got it started. And I support this because of the error that Codes made. I do not support this as a precedent for topographical issues.
So this is a narrow kind of...
Very narrow, and it's the only reason.
And
And if it were the Red Group coming here, the previous owner, I would be in total opposition because they were terrible landowners. But the reason I really wanted to stay to make a statement here is that the house next door was torn down this week, and I will not support them coming with the topographic because they basically know
Understood.
what the rules
So, and it looks like they kind of changed it a little around.
No, I really appreciate what they did.
So any questions for the applicant?
Oh, for the record, our hardships are the topography and the not self-imposed hardship, given the error that occurred.
Yeah.
Okay. Joey, it will conform to all other aspects of the contextual
Yes, sir.
overlay.
Size,
And then
footprint, and
if
height.
there is not a garage, I guess the homes don't have a garage there at all?
They will not. The original drawings did have those. They're going to convert those to living space and adjust the plans accordingly.
Any other questions? Let's close the public hearing. Discussion. So this is a very interesting case that literally the person that turned them in, the very capable lawyer, Joey Hargis, reached out to him and they changed some things and they agree. And I'm glad that the neighbor said that basically he's still against these just in general, but this particular case, given that this was given an error and with the changes, he'll support. So is there a motion?
I make a motion that we grant the request of variance based on the hardships identified by Mr. Hargis.
Motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. Good luck. John Michael.
Mr. Chairman, the next case to be heard by the board is case number 2017-189. This is another short-term rental case, technically an item A appeal filed by Barry Rigby, the appellant and owner of the property at 2322 Medina Drive. The permit application was denied based upon prior operation of the short-term rental property without the legally required permit. Zoning map shown here shows you the subject neighborhood where Modena is located. The aerial shows you the structure in question. Now, is there anyone here in opposition to case number 189? Seeing no one, Mr. Rigby, you'll have 10 minutes to make the desired presentation to the board. Please introduce yourself by name and address and take up the board as you need.
Press the button on the base.
Oh, yeah. There we go. Okay. Barry Rigby, owner of 2322 Modena Drive. Yeah, similar case. I'm sure you guys have heard this many times before. I created an Airbnb listing simply just to kind of see what would happen. I had the instant book feature on, and before I knew it, I had ads. Within less than a week of when I created the ad, I received a notice from Mr. Osborne stating that I was in violation of the code. I immediately contacted Airbnb. I contacted Mr. Osborne. It was a Friday afternoon, so I didn't actually hear back until the following week. But I took the ad down. At that point, the following week, started the process to actually get the permit, do everything the right way, created everything I needed to, went around with my neighbors, had them sign the permission, or not the permission, but the notifications and everything. But when I went into the codes department, realized that my property had been flagged, and so here I am today.
So did you actually rent the property?
I had guests that came in before
Oh, the button.
I thought I had it pressed. So I was cited for advertising, took it all down before I was able to have any guests, but some people did come and stay for the weekend before the ad was taken down, correct?
Now, walk me through this. You've heard about this great thing called Airbnb, short-term rental, and so you said you were almost experimenting by putting, what did you say? What were you trying to do?
So I bought this house about a year ago. A good friend of mine lived with me, and he took the extra room. And kind of an emergency situation came up for him about 2 months ago. He up and left and moved home with his family, left me with a spare room and double my mortgage. In the process of looking at options as to figure out how I could pay the rest, realized Airbnb might be a good option for me. So I created an ad, just put a couple pictures up, published it live. I had frankly no idea that I needed a permit.
Why didn't you know that you needed a permit? Because we have the author of the Airbnb short-term rental permit sitting in the front row, Councilman Berkeley Allen, and she informs me a lot. When I hear from people like you, this was all over the news. You should have known. How come you don't know?
Yeah, right. And of course, as soon
as button.
Looking back in hindsight, I'm surprised that I didn't see this, but again, I'm sure you've heard this argument before. Airbnb does not require you to provide evidence of this permit. I kind of assumed that they would, and they even have some information on their website as well. I should have seen it. I should have done my research, but like I said, I didn't. I just created the ad, figuring I would get all my ducks in a row, once it all came to fruition. And like I said, once I received the notice that I was in violation of the law, I began researching, did everything as best I could, and tried to get the permit, tried to do everything the right way.
Did you receive the notice after or before the people stayed in your place?
Literally same day. Before.
So they're like bringing their bag, they're pulling up from wherever, their weekend to Nashville, and here's this in the mail.
But the notice was for advertising, and so immediately, like I said, I took everything down. I contacted Airbnb. I had to have them cancel all of the existing reservations.
How many existing reservations did you had?
I think there were 6 or 7.
And they all got canceled immediately?
Yes.
Okay.
Well, I asked Airbnb to do that for me.
Yes.
They took a few days to get the ad down because they had to go through their own process.
Okay.
But yes, I made sure I was like, this can't be online. Take everything down, cancel the reservations, nothing until further notice.
And now you're in front of us.
Yes, sir.
So I'm going to ask you the same question that I asked the last person. So what did you learn from this situation, and what do you want us to do?
I learned, I guess, do more research, and also I learned that the instant book feature is dangerous because, as you probably know, Nashville has become Airbnb's #1 destination. I should have looked more into it. Like I said, I kind of was just in a panic after my roommate moved out, trying to figure out a way to cover the mortgage. I should have done my research, and what I ask of you today is to recognize my due diligence and doing everything the right way, paying for the sign, mailing to my letters, trying to do everything by the books, recognizing my mistake, and trying to make it right.
Any questions for the person appealing the zoning administrator's ruling? Okay, thank you. We're going to close the public hearing. Discussion. I think what's interesting about this case, and like I said, Airbnb's obviously in business to get people to book, that you could set up this situation and basically you post an ad and almost immediately, especially if you're in a city like Nashville, it's so popular, you get bookings. And that is just kind of the nature of the website, popular to the city. So here's somebody once again who Council Lady Allen did not know about our laws. Does anyone have any suggestions, motions? So as Council Lady Allen knows, that, the penalty is a year, but as amended, they allow us to take things into consideration and to consider less than a year.
It seems to me that this is the same as the previous case. So I would move that we find that the zoning administrator was correct in his assessment, and we grant the ability for the applicant to apply for a permit today.
Okay, this motion's been made. Is there a second?
I'll second.
Motion's been made and properly seconded. Any discussion about the motion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Opposed? Passes unanimously. So just like the last person, we basically took everything into consideration that you said and being truthful with us about when you posted and the people coming. And so you are now, instead of having a year fine, which is what you were facing, you are now eligible to apply for a permit. So do not post, do not advertise, do not rent until you have gotten a letter from the city saying you are qualified and you are eligible for this, but you are eligible because of our ruling today to apply. Okay? Thank you.
Thank you, and thank you for your time.
John Michael.
Mr. Chairman, the next case to be presented to the board is case 2017-192. Terry Hamilton's the appellant on behalf of the property at 438 Wingrove Street. The request is for a variance from, first, garage door orientation on the subject residential lot, as R6 alternative zoning district lot. And additionally, a variance for the width of the driveway here at this address on Wingrove Street. Originally, there was a request for a variance from the sidewalk requirements. I think that is reflected both in your docket and in your case packet. However, that request for variance has been withdrawn as the appellant, to my understanding, now intends to construct the sidewalk as required under the current law. Mr. Joey Hargis represents the appellant on this case for Wingrove, case number 192. Again, the site plan shown here gives you a proposed layout for the HPR development and the photographs from our recent site visit to the current version of the subject property, the view up and down Wingrove to the left and across the street in the lower right-hand corner. Is there anyone here in opposition to case number 192? Seeing no one, Mr. Hargis, you'll have 10 minutes to make the desired presentation to the board.
Thank you, John Michael. Mr. Chairman, members of the board, Joey Hargis again, Baker Dawson. We are asking for a variance. We would remove the sidewalk variance, and I think you'll note in your letters of opposition, both letters, one specifically was all about sidewalks, the other generally wanted us to build, so we are going to construct those. I did talk to the councilman for the hearing. I believe I had to step out, so I did not hear the councilman's remarks. Hopefully he's supportive of our request, but in this instance, this lot is extremely steep. This lot drops almost 11 feet from the point at which you see the back of our client's proposed building to the rear of this property. So twofold here are the garage door openings in R6A and a parking width area greater than 12 feet. To provide any parking on this property is a must. Otherwise, it's on-street parking, which no one wants. And I do not mean that as a threat in any way, but it's the practical reality of this lot. This particular lot here on Wingrove is, I believe, one of the highest points on this street. And as I talked about, my hardship is the steep topography, which John Michael's camera does not do justice. And I'll put in for a new camera for you, sir. It's probably the same camera. It's been here a while. But you can tell this site here. And new sidewalks will be constructed along the right-of-way there.
So Mr. Hargis has agreed to take the sidewalk variance out and talked about topography. Any questions for Mr. Hargis?
Well, is there an alley on this property?
No, sir, there is not.
I mean, I guess, the problem I have, and I understand the hardship and reconciling the hardship with the overlay, is that, and I guess it's late and I'm not very, I just don't know how to say this thoughtfully. It just seems like it's a project that's like every other one in town, and the overlay is doing everything it can to not have something like everybody else is building, which is pave the front yard and have garages on the front, and that's the spirit of the overlay. And all this does is ask us to go against the spirit of the overlay because there's a slope, and it just seems like I'm not discounting the fact that it's a hardship, but I really, why is this lot so unique that it can't address some of the other, aspects?
Sure. No, I get to your point, and that's sometimes, and I've expressed this to the councilman folks that were here. The overlay, I think, well-intended, but it's created to create a cookie-cutter design that doesn't fit on every piece of property in that specific geographical area. And I think there are instances like this one, like I'd argue later in future cases, if there's some condition in which both the state law and the metro law allows you to grant a variance to, that it makes sense to apply it to exempt from this case. And I would submit to you, and those pictures really don't do it justice, this is an extremely steep lot. Redesigning this in such a way as to put one home elsewhere at the bottom. If you'll note, can you go back to the site plan, John? You've got your setback portion in there. You would essentially be creating one house sitting much further down below the bottom in doing so. And that's not really in keeping with the way this neighborhood is laid out with other structures and homes that are laid out this way. Even your own photographs, the subject lot there has an existing driveway in areas that are well beyond 12 feet. So I'd submit to you that although the overlay, and this is not an overlay, this is R6A, it functions just like the contextual overlay. It's written, the wording's verbatim. The intent of that is to provide that. But there are instances, and I'd submit to you that this is one of those, that the topography is such that functionally it cannot comply with the regulations. And that is classic textbook case law hardship under state law, that if there's something that prohibits compliance.
Well, I agree with my colleague, and I'll go further to say that I don't think the topography has anything to do with the fact that I realize this is R-zoned, but you don't have to build two on an R-zoned lot. You can have a single-family home. And I just think that there's too much being crowded on this site, which is prohibiting them from driving along the side and coming into the garage from the side. So I don't think I'll support the variance request. I guess we're not deliberating, sorry.
No, we're not. Okay, so other questions for Mr. Hargis? Do you have anything else to add?
I don't, other than state hardship, again, is the topographic conditions on the property.
Okay. And as you mentioned, you had two letters of opposition, but they had to both do with the sidewalks, and so you've agreed.
We did, and we're obviously going to construct those, and I think the councilman talked about too, he's supportive of this request. Obviously, I believe he testified that. I hope I did. Again, I stepped out. That was his intention. He said he was going to say.
Okay.
Which, Councilman Sledge, if he were opposed, he would certainly let you.
Sure, absolutely. Okay, thank you. We're going to close the public hearing.
Well, I'm sorry, I did deliberate before, but my comments still stand.
Okay. So, to me, this is a situation, we had two people oppose it, mainly because of sidewalk issues. It's not. We have the council person who's for it,
Is there a letter from the council?
Colby was here. So the question is this a hardship with topography? As Mr. Hargis said, it's one of those, photos don't do it justice, et cetera, et cetera. You had some concerns.
Well, I get, I guess the only way I can condense what I have to, how I'm feeling about it, and I don't know, but it's if it's such a unique piece of property, why does the solution look like everything else is being built? So that's just where I'm coming from. I mean, if there was, and not that it's not unique, I don't know. There's just too many of these 50-foot lots or 40-foot lots that they're squeezing two things. I mean, it looks like an awful lot of things that are happening, and I think that at some point, the contextual overlay. I mean, if it tried really hard to not have front-facing garages, or if it tried really hard to do something else, then but it,
But he said there was no alley in the rear, just really sloped badly, you know.
well,
so-
you know, or it's narrower in the front to back and you have a garage. I mean, there's, like I said, we're not here to design for the person. I'm just saying that it feels like a very well-seen footprint, and we're being told it's very special, and I don't see a special attempt at a solution. And I'm struggling with how important that effort is versus the contextual the zoning language, which is like the contextual overlay.
You know, I still just, you know, there's real no opposition for the way it looks and just building like this on this lot and the council person's for it. So, you know, I would have to just trust that there are some topography issues that made this kind of necessary, right?
If there's no more comments, I'll make a motion.
Okay.
I move that we deny the variance request based on the hardship wasn't proven to relate to the garage door replacement.
Okay. Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. So hands up. Okay, so 4, and then against 2. So it passes 4-2.
The motion passes 4-2. The project is denied.
The motion passes 4-2, yes.
And therefore, we will move forward to the next case, which is case number.
Was the motion, it was for garage doors? Yes, it was. Okay.
And if yes, that would address the first variance. The board can, of course, take a second motion with regard to the second variance request with regard to
The driveway, because we've already,
driveway
the
width.
sidewalk's off the table.
You know, I would even be willing to not take action on the second to have them, or defer the driveway motion if they want to give them a chance to come back with another potential plan. I mean, I don't want to deny a driveway and then have it completely.
Mr. Hargis?
Is there any way that I could speak since I'm involved in this?
No. So the question is, we can defer the rest of it from the driveway and come back. Or we could just vote on the driveway. Mr. Hargis, should we defer the driveway or should we?
Yeah, let's defer the driveway.
Okay. So John Michael, do we need I guess we need a motion to defer.
It's cleanest to get a motion to defer that second component till our next meeting.
Okay. Okay, motion to defer the issue on the driveway. It's probably been seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Joe, one meeting, yes. Aye, opposed? Okay, unanimously, we're going to defer the driveway issue to one meeting. Okay, John Michael.
And of course, that matter will be heard near the top of the docket at our August 17 board meeting. Mr. Chairman, the next case to be presented is 2017-193. This involves the property located at 2304 9th Avenue South. In Council District Number 17, you've already heard from Councilmember Sledge with regard to this project. Property shown here is in the R8 zoning district. That's noteworthy because it is an appeal from the appellant and owner of the property, Sarah Orantia, to convert detached garage space for an accessory building with residential use. This is a lot size variance request. The aerial shown here gives an indication of the subject property vis-a-vis its neighboring properties in the alley to the rear. The site plan, although there are several pages in your packet of the floor plans and elevations, this is in fact the floor plan for the secondary structure behind the main structure, shown here from my recent site visit, as it faces 9th Avenue South. Then the views up and down 9th Avenue South on the left side, the view directly across the street with the always stylish Metro vehicle there front and center to the right. Is there anyone here in opposition to case number 193? Seeing no one, the appellant will have the opportunity to make a 10-minute presentation to the board. Please come forward, introduce yourself by name and address, and explain your request for the variance on lot size.
Hello, my name is Dan Oranti. I'm the father of the owner, Sarah. And my request is to actually just put a studio apartment, studio music, I'm not exactly sure of the term, above the garage that already exists. The neighborhood seen on the photo has multiple garage studios in there. Sarah wants to use the studio for songwriting and recording. Her house, which is a significant size for it, however, is an open concept, and it has a lot of echo, and a lot of work would have to be done to stop the echo in that, and she felt that it would be a lot easier for her to put that in the garage attic space. She would also like you to know that that her band that she performs with is in Los Angeles most of the time, and when they do fly into Nashville, she would like to also use that as a sleeping space when their band is there.
So, I mean, I guess the, what is in that space now?
It's a two-car garage, and the attic space is just storage space.
But it has stairs that go up to it?
No, the drawing that you have, excuse me, that's a frog in my throat. The drawing that you see is a concept drawing that an architect drew. The stairwell would be in where her backyard is, which is completely fenced in, and the door would be above on the outside in where her backyard is. So the only addition to the garage space was the architect actually put a little dormer on the east, I guess it's the east side of the house, or away from the house towards the neighbor's garage, to just add a little bit more space into that area. And I believe it was because the slope of the garage is very steep, so every foot to make a foot-high wall, it would have to be in 5 feet to have a 5-foot wall on their side, so it would significantly cut out the space without the dormer.
So, I mean, we got a fair number of letters from our neighbors that were opposed to this because they said that your daughter, this probably is not, this is their impression, this was not her primary residence. She was often gone, and it was rented, and they thought that this studio was just another place to rent.
Well, after hearing a few of the Airbnb stories, she does use the house as an Airbnb when she is not in the property. We have no intent of making the garage space part of that Airbnb. She is an actress, singer, songwriter, so she is in Los Angeles 7 months out of the year, but she comes back on hiatus, so she's on 3 weeks, comes back to Nashville because this is her permanent address. It's the only home she owns. And so, so she does rent it out when she's not here, but if she has this studio, she would be able to rent her house and sleep in the studio if somebody wanted to use her house at that time. But again, we don't have any ideas to use that studio as an Airbnb.
Any questions? Anything else to add? Oh, yes.
Is the studio a permissible use?
We could ask John Michael.
Well, I know that I've talked to codes, and everybody has said that everything I've been doing is legal for code-wise and everything.
John Michael, I know that there was a case for home studios in front of the Metro Council years ago, and I'm not sure if that ever got resolved. So Mr. King wants to know if having a studio in this is a legal use.
Thank you for your thoughtful question, Mr. King and Mr. Chairman. I have not reviewed the land use table. I can do so to see if home studio is considered home occupation vis-a-vis the allowable land uses under 17.08 of the zoning code. It is a commonly understood fact that in Nashville, there are, in fact, home recording studios. You are correct, Mr. Chairman, that the Metro Council, probably 2 Metro Councils ago, because the took up this very issue, the sponsor of a bill that was widely discussed and thoughtfully considered by our council was, in fact, Councilmember Mike Jameson, who is now multiple council members removed from having been the council member for his district, and on to bigger and better things as the legal advisor to the Metro Council. So I'm saying that just to date the discussion itself to which you make reference. I'll be glad to take a quick look at the land use table and get you a little more feedback with regard to the question of a studio. Of course, that's not necessarily what's before you today.
Right, I know.
And to the question that I anticipate next, is there in fact a legally issued permit for the short-term rental property? Yes, there is an owner-occupied permit that was issued in 2016 with regard to this property.
Okay, thank you.
So what's the hardship? With a variance request, you have to prove a hardship, which is usually associated with the land.
Yeah, I mean, honestly, the hardship was just the fact that she just needed the space for her band and to write songs and record in a better sounding spot. I mean, that's really basically it.
Maybe you said this, but does your daughter own the property, or are you the owner?
She owns it.
She owns it, but she couldn't be here today.
She is filming in Los Angeles today.
Okay.
Any other questions? Anything else to add?
Well, and I guess I kind of left out I went through codes and everything else was permitted. The drawing was permitted. The reason for occupancy of it was permitted. But when I had to go through one step, he didn't realize that the lot size was 300 square feet too short, and that was the only thing that we're asking, is that you give us a variance on the lot size.
Okay. Thank you.
Thank you for your time.
We're going to close the public hearing and discussion.
Well, we do have opposition.
Is there?
Of letters, I mean.
Letters.
I'm sorry, in the file, we have some opposition. I do think we have jurisdiction to entertain the request. I would prefer to hear from the applicant. What do y'all think about having her appear?
Board members?
Or not?
Would that impact your decision, I guess is what I should say.
Well, I'm actually more at a, I don't know if confusion is the right word, maybe I'm just tired. But they're asking for a variance on the size of the property, which would make what they're doing apparently code compliant, were it not for the small size of the lot. So I'm not 100% sure I have a good grasp on what a hardship is for that. I mean, in a way, what they're requesting is the hardship, and I'm not trying to be coy, but
John Michael, lot size variance hardships. I know lot size variance is a new animal to us.
Yeah, and that's something, Mr. Chairman. Mr. Harper's landed on a really good question. The board has grappled in the past, and when I say in the past, I don't just mean this iteration of the board in the last year or so. I mean historically, in the several years that I've been at these board meetings, boards struggled with the concept of a lot size variance, because when you talk about a hardship, what's the hardship for the size of the lot? I mean, conceptually, you look to the shape of the lot, the topography, some grand old trees we're trying to save, a creek that runs through the middle, something about the land itself. And although, very technically, appellants are allowed to bring a variance request with regard to lot size, and although the board has granted some in unique circumstances, I think that everybody that comes before the board with a lot size variance request struggles to pin exactly what the hardship is. So forgive me for what must seem like a non-answer, but I think that you've at least correctly identified what the tough question is. It's unclear what a variance theoretically would be based upon in terms of hardship.
More discussion.
I guess here's how I look at that. We don't have an applicant here. There are some complaints about the way the property is otherwise being used. And while what they're asking for would be allowed if they had 300 more square feet of property, they don't. And I sort of feel like the decision we make affects this entire piece of property. So I would sort of tend to deny the motion or give her an opportunity to be here and talk to us further. That's sort of how I see it.
Board members, would we like the applicant, given her schedule, she could come here to answer some questions?
I'll go along with that.
I mean, I would entertain a deferral, and if she wants to show up, fine. I mean, I don't know that I would make that a condition, but I'm happy to make a deferral for that reason.
Okay. So let's have our person come back. So, as you can see, the board members have some specific questions that they want to ask the homeowner. We are leaning toward deferring this case until we could hear from her. Our board meets the first and third Thursdays in the month, and you're looking to say, well, she's out in West Coast California.
Yeah, again, I can check the calendars of her hiatuses. She's on a network TV show. She films whenever they feel like they're going to make her film. And so, it's one of those things where if she has a hiatus, like I said, it's 3 weeks on, 1 week off. But I have made appointments for her on that week off, and then they decided that, you know what, we need to have them here. So it's one of those things where, unfortunately, she would love to be here. She would love to have been here today. Regarding I know you said you have some complaint letters. I don't know what those letters say. I have no idea. But if what I heard you say was they're complaining about how the house is used, we legally have an Airbnb license. We use it. We submit our taxes. We pay everything that we have to do. We've done everything possibly legally. We've never had the police call on the house. We've never had any complaints to us via the house. So yes, it is an Airbnb, a legal Airbnb, and it truly my daughter as a 23-year-old is very mature and has done everything she can possibly do the legal and the right way to do it. And so I don't know that she can make it. I'll try to have her come, but I can't guarantee it that she would be here. So unfortunately, that's the issue.
Okay. Does that change your opinion on anything, or should we at least try once to see if she could be available in the next few months?
I think we try once.
Okay. So what we're going to do is defer this, and hopefully, online, our board has meetings, but they're basically the first and third Thursdays at 1 o'clock here. And so, John Michael, what's the kind of?
Mr. Chairman, I think looking at the next three board meetings, those are August 17, September the 7th, and September the 21st. And that's what you've made reference to, first and third Thursday of every month. We need not pin a specific date today, of course, if the board were to go through with what it looks like it will, and that's move to defer this case to a later date. That would actually give the appellant the opportunity to identify a date to be present. And if the board wishes to proceed in the absence of the appellant, of course, you're more than able to do so. And if they can be here to answer some questions, then it sounds like that would only serve to help the case.
It would also give the appellant an opportunity to address the issues with the neighbors. So that would be potentially as beneficial as being here.
And Mr. Chairman, the only other clarification, obviously every letter we get in support of or opposition to every case that we have is public record.
Yes.
Feel free to email Mr. Orantia and just ask for whatever the whole case file is. We'll send it to you, and you'll have a copy of every letter that's been submitted.
And I emailed
that's
from
all
the
fine.
letter, the address from the letter that we have? Okay. All right, and I will say that I know she can't make the August one, possibly the September one.
Okay. Well, let's just kind of go with that. So can I have an official motion then?
I move that we defer the hearing to a later date. The applicant can contact the staff to determine the appropriate time to set the hearing.
Okay, motion's been made. Is there a second?
Second.
Motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. We will work with the applicant to hopefully find a date where she could be here in presence. Thank you.
Thank you.
The next case to be presented to the board is case number 2017-195. Sunday Camp, the appellant, on behalf of Dream Inc., the owner of the subject property located at 1803 Ashwood Avenue, shown here on the zoning map, an R8 zoned property, has filed an Item A appeal challenging the zoning staff's denial of a short-term rental permit. The permit application expired before the permit was in fact issued. Board members, I will note that the vast majority of the cases that you're seeing these days with regard to short-term rental are scenarios where people operated before they had a permit. This is a matter of not finishing the application process, namely by doing the final payment of and receipt of the permit itself within the 90 days allotted by law pursuant to BL 2016-381. With that, a permit application expires at the end of that amount of time. However, with BL 2017-608, the consequences of that are not all of the permits that might have been available once upon a time are still available because of changes in law that have taken place since then. So a unique set of facts here, and I wanted to give that to you on the front end because I think it helps add a little color to the appellant's case so you understand that. Naturally, I'm happy to try to answer any other questions that may come up.
Before we get started, kind of walk us through A to Z of someone getting a short-term rental permit. What do they have to do?
Come down to the Codes Department, apply in person, provide the required documents, which as the board knows, includes the appropriate insurance documentation, the appropriate evidence of notice to the adjoining property owners, includes a simple floor plan rendering or drawing to give an idea of the layout of the house or apartment or condo at issue. Once you get through all of that, which is handled by the zoning examiners at the zoning division of the Metro Codes Department right here on our Fulton campus at the Metro office building, then assuming approval of all of that information, and also the affidavit confirming that there is no homeowners association in place, or if there is, there are no guidelines from that HOA that would forbid this type of use. Then you go through the process of linking up with the fire marshal to have an interior inspection of the subject property so they can confirm the ingress and egress is appropriate and that the appropriate smoke alarms or detectors are in place. So there are a number of steps involved, to be sure. What we find a lot of times is people go through the process with the fire marshal. Maybe it gets slowed down there. Maybe they have to do some corrective measures to get the approval from the fire marshal. But at the last step, as with the building permit, Mr. Chairman.
If this was Schoolhouse Rock, you know, they're walking over to one side and walking over to the next side. They haven't gotten their stamp yet saying I'm a law. So what needs to happen at the end?
In order to stop being a bill on Capitol Hill, Mr. Chairman, you gotta pay for the permit. You gotta show up with the permit text, obtain the permit, get it in your hand, pay for it, and walk out. That is when you have a permit, and you have to do that within 90 days pursuant to local ordinances.
Thank you for that little education. So please identify yourself, your address, and are you in opposition? Okay, opposition. So we'll have 15 minutes per side.
And Mr. Chairman, I'm going to recuse myself. My husband does business with Sunday and Joe, and I think it's probably best to not be involved in this one, and we'll exit.
Okay. Thank you. Please identify yourself for the record and your address. Oh, press the button, the red light. There we go.
Sunday Camp, and I'm at 1403 Elmwood Avenue.
Okay. So why are you here, and what happened in that long procedure of trying to do this? Yeah, just, it'll stay on.
It'll stay on, okay.
Yeah.
Basically, the gentleman who work in my company did the steps. They met with the fire marshal was the last step, and as we look at our permit application, it says approved, approved, and then it gets approved. Well, it went in a file, and everybody thought it was approved. And then I went to look for another building permit online, and I was like, what does this mean, expired? And I was like, what does that mean? And I called, and I came down here on June 22nd and found out I did not pay, or we did not pay $50. And then I was told to do this, apply, tell the neighbors and go through this process. So I did that, and that's kind of where I'm standing. It's kind of embarrassing, but it's $50 that we did not pay, and I've lost the opportunity based on the 90-day window to do what we had hoped to do with this property.
Okay. So what are you asking us today?
That you let me pay the $50 and continue as intended, with the permit.
Okay. Any questions for the applicant?
Well, you understand that I think our ability is to allow you to apply for the permit we don't know if there is any availability of permits at this time.
Okay. So I
Is
was,
this an owner occupied?
well, I have a long-term renter that lives in the building,
But what you applied for, was it an owner occupied or a non-owner?
a non-owner occupied.
Okay. So, any other questions? Anything else to add? We have opposition, so we're going to hear from the opposition, then you'll come back and we'll, yes.
Sit here?
Yes. And you'll have 13 minutes to respond, or 45. Please come forward, opposition.
I'm Barbara Nelligan, 1802 Linden Avenue. Mr. Chairman, good afternoon. So basically, if you look at that photo, right on the other side of the alley is our home and backyard. So really, we just would like to delay since the owner doesn't live there, an Airbnb being just right across the alley from where we spend our time and entertain. So that is the opposition.
Okay. Any questions? Okay. Thank you. Let's
you.
hear from the applicant again. To respond, rebuttal. Okay, the person in opposition says they just don't want to live across from an Airbnb. What's your response to that?
My response is, I also live in the neighborhood, and I have a tenant who lives there, or will be living there, so it's sort of like a residence in the sense that it's not going to, I don't know, I'm very responsible. I don't know what else to say. I'm going to qualify. It's my home. Ultimately, it's my piece of property, it's my home. So I'm not going to, I don't know, I would be very respectful of the community.
Okay. Any other questions? Okay. We're going to close the public hearing.
Mr. Chairman, the only note I would make, as is always the case, Robert Osborne, the property standards inspector from the Metro Codes Department who handles short-term rental inspections, is in fact present if the board has any specific questions. If not, that's fine, but I'd just like to remind you that he is here. I know that this case is kind of unique compared to some of the others that have to do with more
Let's
traditional.
hear from him. He came and sat through all of our meetings, and you're the one that provides all these cases on our docket. So, Mr. Osborne, welcome. And please, let me ask you this. How did you become aware of this property, and what's the kind of procedure that you go through when you're looking into potential violations or, people that don't have permits?
So I'm submitted with the BZA docket like everybody else. I go through and I check all of those cases that are short-term rental related to see if they are still advertising and or operating. This was one I did find that was. It had several reviews from June and one from July. My understanding is that she filed her appeal into June. So at that point, I made a site visit, I think on Monday, and posted a stop work order. Because I got the BZA docket last Friday, and I looked into it then.
So you basically look at all of our permits that we've issued for short-term rentals, and then you go and kind of look at some current postings to see if they're actually permitted.
Correct. So I search Airbnb, VRBO, zoom in and out on that map to see if I can find any advertisements for that particular property.
This must be a full-time job nowadays.
Most definitely, more so.
Okay. So you were the ones that you alerted the codes department about, this? Okay.
Correct.
Any questions of Mr. Osborne? No? Thank you for being here. Okay. I think we're in deliberation. Have we? Do you have anything else to add?
I don't think so.
Okay, we're going to close the public hearing. Time for, one more question. I have a question.
Sure.
So Mr. Osborne said that you were renting this during the time where you didn't have a permit. So when did you find out that you didn't have a permit?
On June 22nd.
And how did you find out? You said you were looking
I
online.
came down here, and I tried to pay the $50, and I was told by, that it was, someone thought I had to renew it. And there was a little bit of confusion.
Right, that's right.
And then I ended up actually having to do the sign and let everyone know.
Right, sure.
Yeah, so that's what led me
So
to.
how many times was it rented?
It was only is rented on the weekends,
But how many times?
at least 4 times
Okay.
throughout the time that I found out till now. And then going forward, I pulled it off. After I spoke to him on the 31st, I pulled it off and down just because I didn't know what was going to happen.
Did you cancel any future?
Well, it's not, you can't, we make mention that we're having, that we're not taking anymore. We're holding off, we're stopping.
You know, some people sign up and I'm coming in 2 weeks. So did you have any of those people?
No, thank
Okay.
goodness, no, we were good with that. So
Okay.
that was a good thing, yeah.
Okay, thanks. We're going to close the public hearing.
Right.
Discussion. So as we mentioned at the top, this is, there's 10 steps to the process. You do 9, and the last is the check. And so no check, no permit.
Okay, well, maybe I misheard, but I thought she had not rented the place yet. Is that right?
She had rented it 4 times.
Okay. I
But
didn't hear
that's
that
when she
part.
thought.
When she thought she had a permit. I mean, I think as soon as she understood that she did not have the permit, and apparently she was already otherwise qualified, but for the payment of the fee, I would be comfortable finding that the zoning, well, what I would say is that I would allow her to apply for the application with the understanding there may be no more permits at this time.
So is that a motion?
Yes, I will make that a motion, that the zoning administrator did not err, but that given the circumstances, she should be allowed to apply for a permit today.
Okay. There's been a motion made. Is there a second? Second. Okay, motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Opposed? Passes unanimously. So here's the deal. We are making you eligible to apply. That is not the same thing about getting a permit. So you've got to go through that whole process again. Now, talk to codes, but there might be a situation where there's no more non-owner occupied permits left or no eligibility at all. So you will either have to have an owner occupied or wait till the Metro Council, who is looking into new legislation regarding this, acts on it. So you cannot post or rent until you have gotten a duly issued permit. Do you understand? Yes.
I have a question in the sense of the long-term person that's there is.
Long-term, short, so this law only applies to people 30 days or less.
Okay,
So
okay, that's fine.
anything longer,
Okay, because you
could do what you want.
All
Okay?
right, thank you.
Thank you. John Michael.
And then there was one, Mr. Chairman.
Yes.
The final case to be heard for the day is case 2017-196. As the chairman presciently noted at the beginning of our meeting to Mr. Helmer, you may have to come back to the Board of Zoning Appeals for some other case in the future. The future is now, Mr. Chairman. Mr. Josh Helmer is the appellant and owner of the subject property located at 72 Murray Street in Council District Number 19. The request presented with this case is for a variance from lot size requirements in the R6 zoning district in order to construct 2 single-family residences. The zoning map shown here gives a layout of the R6 district here just not too far off. The nearest cross-section is Fane. This is not too far off of Charles Davis. The aerial shows the undeveloped lot relative to the other structures nearby, all residential in this area. The proposed site plan gives you the layout that's indicated for this project. And from my recent site visit, the face of the undeveloped lot, the view up and down Murray Street to the left, and the view directly across Murray Street on the right. The specific question always comes up. The requirement, of course, in the R6 zoning district is for a 6,000 square foot lot. This is 225 feet short. The difference between getting single family versus two family is that 225 feet, hence the request for a variance today. Is there anyone here in opposition to this case? Seeing no one, The appellants will have 10 minutes to make the desired presentation. If you would both identify yourself by name and address, and then address the board.
Josh Helmer, 1071 2nd Avenue South. Thanks for having me back.
Charles McTorry, 600 Monte Carlo Drive.
Let's proceed.
Okay, so we purchased this property recently, and I spoke to Councilman O'Connell if there was a possibility of building 2 instead of 1 over there to attempt to get some density in the neighborhood and spark some building. We spoke in length about what we had planned to build and what our target price was for it. And he said that it's a very sensitive neighborhood, but as long as we kept our square footage proper and kept our price points proper, that he thought it was a good idea, that any infill projects over there were a good idea. He said that he would try to take a look at all the paperwork we put together and send a letter of recommendation. I'm not sure if anyone has received that letter from him. But he was for this, as long as we kept the houses at a normal size. What we're proposing is $1,329, and we're looking at the $249,000 price point. If we are only allowed to build 1, that's not a problem. For future, we'll just have to hold this. And I guess the growth will be delayed a little bit over there, and we're hoping that there can be some growth in a neighborhood that's quasi-dead, but we can still build homes in a price point where neighbors that exist over there could purchase a new home if they wanted to.
Okay. Any questions about this?
How do you get to Unit A or Unit B?
Unit B, there's an alley behind it. So what we would do is, Unit A, there's an existing apron, so we would have a front-facing garage, and Unit B would have a rear-facing garage off of the alley. There'd be on the, I guess what is the east, I think that's the direction, the 10-foot setback on the side of Unit A, there would be a walkway to Unit B for the mailman and for a homeowner if they parked on the street. So there's a lot of clearing that needs to be done. That's actually 3 lots. We haven't had it staked yet. We wanted to get through this before we actually had it surveyed and started tearing trees down.
That's 3, and you're here on this 1.
Correct. We don't own the 2 other
Is that the one on either
vacant
side of the one shown in red?
Yes.
That photo we just saw?
Yes, ma'am.
You said you do own the 2 others?
We do not. I believe there's an investor that owns 1, and then I believe 1 is city-owned. A tax buyback. So the 3 collectively are kind of covering or collecting trash, and we're hoping to spark the developer next door to do something, and then the city-owned lot will probably be affordable housing one day.
Thank you.
You're welcome.
Any other questions? Do you have anything else to add?
I don't think so.
Okay. Thank you. We're going to close the public hearing discussion.
We don't actually have anything from the councilman that I saw. Did you see anything? But it's my inclination that, based on what they're requesting for the small amount of lot size variance, I think it would be an improvement over what is there. It seems to me I would be in support of the requested variance.
Okay. Any other discussion? Do we have a motion?
Yes. Point of order.
Sure.
Do we have to find a hardship?
You heard John Michael earlier talking about.
But do we have to actually say it? We never got to this point on that case.
I will answer that, less from a point of order perspective and more from a legal perspective. Yes, I do think that you are required to find a hardship, and it is certainly recommended that you state on the record what that hardship is.
And I would opine that the small lot size is the hardship for the small lot size.
Narrow. Let's say narrow.
Narrow.
Yes. So,
With that addendum, I would keep my motion.
motion's been made and properly seconded. Any more discussion? Seeing none, all those in favor signify by saying aye. Aye. Oppose? Passes. Oh. We have 4-2. Okay. 2 in opposition. Very good. Okay, it passes then.
And with that, Mr. Chairman, you've completed all the hearings for today's meeting. The next BZA meeting will take place on August 17 at 1 p.m.
Thank you for your time.
Thank you, thank you.
Thank you. And I apologize for any earlier frustration.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.